But may I mention item number 49, my lord? It may come up before appropriate bench, my lord. It's a dispose of matter, my lord, application in file, my lord, unfiled appearance, my lord.
49. When to be listed?
Well, it should go to court number 14, my lord.
Court number
14.
14.
Because that was disposed of by his lordships and we filed an application for complete.
Acha.
It may be.
Mr. G. N. Sarula, learned counsel for the.
I put a respondent, your lordship. Matter will be fixed at 14th of this month, 14th August. For
14th of August.
Yes, for
No, we cannot fix the date. They will, that's it.
we have to
appropriate bench.
regarding their petition, we have to file an objections. Today we are supposed to respondent was suffering from.
Submits that the original FAO was disposed of by the court number 14.
Yes.
And accordingly, it is
Right.
submitted that the matter may be directed to be listed before the said court. Pair is accordingly allowed. Rest is shall do the needful in this regard.
Much.
May it please your lordship. Lordship, I beg to mention.
Volume. Yes.
Lordship, I beg to mention for listing in order columns. Lordship.
When?
Any date, Monday or Wednesday.
Monday?
Lordship. Already notice issued, but execution is pending, Lordship. So,
Okay, Monday.
Lordship, obliged, Lordship. And another MSc appeal matter, Lordship, for orders.
When?
Two order matters, Lordship.
When?
Any date, Lordship.
Okay. If possible on same day.
Lordship, obliged.
Okay.
May I please lordship? Prior for listing lordship in MEC appeal lordship.
When?
12 lordship.
12.
12.
May not.
14.
Applied.
May it please your lordship. Lordship, with regard to item number 52, my lord. Lordship, already Dusty has been served upon the respondent on 4/7, my lord, 24, but they have not entered appearance, my lord, till date. So this matter may be taken up after 2 weeks, my lord. Stay matter.
Miss M. Bora.
B. Bora, my lord.
B. Bora, learned counsel for the petitioner. Press for listing the matter after 2 weeks. Pair allowed.
I'm obliged.
May I please, your lordship? Lordship, I beg to mention for listing on a IA for tomorrow, lordship.
When?
Tomorrow, lordship. Lordship, an INR or lordship, IRS is already admitted, lordship, but money execution case was filed, Lord, which is fixed on 12, lordship.
Tomorrow may not be possible. Friday we may try.
Lordship, on tomorrow, because we have filed it on 18 July, lordship. Till now not listed, lordship.
Tomorrow is hearing day. And as many as 19 matters have been listed already.
The execution case is fixed on Monday, lordship.
We will take it up on Friday.
Friday, lordship. Much obliged, lordship.
I'm praying for listing this matter, my lord, 19th, my lord. CRP, my lord.
19.
19th.
Please, your lordship. Lordship, I will listing for a matter, RFA matter, on any day after next week.
Okay. Take it that from him.
14th.
So I am praying for listing of MSc hearing.
When?
Any date, Lord.
On
When?
16th.
My lord, item number 39, I am for the petitioner, my lord. They listed after 2 weeks, my lord. Consent of the from other side also taken, my lord.
39.
39, my lord. After 2 weeks, my lord.
With consent from the other side,
Yes,
Mr.
yes.
Your good name?
B. Hussain.
B. Hussain, learned counsel for the petitioner. Press for listing the matter after 2 weeks.
Yes.
Pair allowed.
May it pleases your lordship. Your lordship, I am praying for listing of an unlisted matter. It is an IA for orders.
When?
Friday,
Friday possible?
Monday, 12. Monday.
Oh.
Deeply obliged.
May I please, your lordship, I beg to mention an interlocutory application which is arising out of a mega appeal, my lords. And it was last listed last year on 15 May 2023.
When do we want?
My lord, in Friday, this week.
Friday?
Right.
Possible?
14th, Wednesday, 14th.
Much obliged.
May I please your lordship? Lordship, I'm praying for listing of this MFA in the orders column, lordship, next week.
On 16th.
May it please, your lordship, I beg to mention item number 32.
30?
32. Lordship, due to medical emergency of the conducting counsel, he will not be able to attend the court today.
Who is your conducting counsel?
H. Burwa. Lordship, may agenda.
Mr. Your good name?
P. Fukan.
Mr. So-and-so, learned counsel appearing on behalf of Mr. S. Barwa, learned conducting counsel for the petitioner. You inform the other side? You inform the other side?
Yes, yes,
Are you sure?
yes, sir.
With consent from the other side, press for listing the matter after
3 weeks.
3 weeks. Fair load.
May, may please your lordship, I beg to mention for listing. IA for delay condonation on next week, lordship, in
On 19,
14
on 14.
of like.
May I please, my lord, I beg to mention item number 30, my lord, 30, my lord. My lord, in this case, my lord, with regard to respondent number 3B, my lord, there is some confusion that whether he is alive or dead, my lord. So I have to take the instructions, my lord. I pray for 3 weeks time.
The office note indicates he has died, my lord.
But I have talked with the client. He says that she is alive. So let me clarify the matter, my lord, after 3 weeks.
Okay. Mr. E.K. Gupta, learned counsel for the appellant, with consent from the other side, press for listing the matter after 3 weeks so as to enable him to obtain instruction in respect of date of respondent number
3B.
3B.
3B. Yes.
Okay. Fair allowed. This is the matter after 3 weeks.
When the LCR was also called for, it has not come, my lord. The reminder may also be sent, my lord.
The learned counsel for the respondent number
1 and 2.
1 and 2 submits that the LCR was called for, but the same has not yet been received. And accordingly, it is provided that recessal is a reminder to the learned court below. Now, learned trial court for transmitting the record forthwith.
My lord, I have paid for listing upon MSC appeal on the next Tuesday, my lord, 13th. Okay.
Yes, your lordship. Lordship, I beg to mention item number 42, lordship.
42.
42, lordship. Lordship, my senior has some personal difficulties and moreover the dusty service, which we have to take upon responding number, lordship, 3 has not yet been, the affidavit has not yet been, lordship. We need some time to file our affidavit, lordship.
Your good name?
SP Sharma, lordship.
Mr. S.P. Sharma, learned counsel for the applicant with press for listing the matter after
2 weeks, lordship.
after 2 weeks so as to enable him to file an affidavit in respect of service of notice upon the respondent by dusty mode. Here is accordingly allowed. Recessal is the matter after 2 weeks. 2 weeks.
Obliged.
I beg to mention for listing
When?
next week, your lordship. On 19th. 19th. On 16th.
16.
Cases, lordship, next week, already so many cases. 19th, Monday.
16 is Friday.
For hearing. My lord, 2 matters are there, my lord. One is for hearing and another one is for order, your lordship. Then one on 19th, one on 20th.
Yes.
May I please your lordship?
Obliged.
Lordship, item number 43 and 44, only adjourn for the day, lordship.
Why?
Some personal issue. sir.
You are for?
M. Islam,
No, you are appearing for?
M. Petitioner.
Your good name?
A. Khatun.
Ms. So-and-so, learned counsel appearing on behalf of Mr. M. Islam, learned counsel for the petitioner. No, for the appellant. Price for listing the matter after. When? Did you inform the other side?
Lordship.
No, you first inform the other side. Only then we will consider your pair.
Items for withdrawal. Item number 53.
Yeah, please, your lordship. Lordship, here I have been instructed to withdraw this.
Your good name?
Jeep Hardwaj.
Mr. Z. Bhardas, the learned counsel for the appellant, submits that he has the instruction to withdraw this appeal. Any objection?
No, my lord.
Mr. Your good name?
A.J. Sharma.
Learned counsel for the respondent number
1.
1. Submits that he has no objection in the event of granting such permission to the learned counsel to withdraw this appeal. Accordingly, we are allowed this RSA stands disposed of on withdrawal.
Interim order, if any, my lord, that may be vacated.
Interim order pass early, if any, pass earlier stands vacated.
54.
Here also same trend.
Okay, same order in 54.
Thank you.
Items for motion, item 1.
May it please your lordship. My lord, this is an increased case, my lord. Here the petitioner has filed a probate case again, for the learned court below, my lord, which was dismissed, my lord. The interim judgment is at least 36, my lord. Your lordship may admit and call to records.
Heard Miss S.B. Sodori, learned counsel for the petitioner. No, for the appellant. This appeal under section 384 of the Indian Succession Act 1925 is directed against the judgment and decree dated 12/6/2024 and 28/6/2024 respectively, caused by the learned additional district judge Nagaon in Miss case within bracket probate number 12 of 2016. It is to be noted here that by impugned judgment and order dated so the learned additional district judge Nagaon, Assam, has dismissed the petition filed by the appellant seeking probate of the will. Peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugned judgment and order. No, judgment and decree dated 12/6/2024 and 28/6/2024. Admit. Issue notice to the respondent returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Registration call for the record from the learned trial court. List the matter after 4 weeks.
Item number 2.
May it please your lordship. What is the transfer petition for transfer of a divorce suit from the court of the learned district judge Jorhat to the court of the learned district judge Hojai, my lord? My lord, I am the wife. I am residing in Hojai. My husband is not maintaining me. So I have filed one 125 case, my lord, and one DV case, my lord. Both of these are proceeding in before the court at Hojai and are fixed on 12/8/2024. Both cases are being fixed on the same date. Now, my lord, after contesting these cases, my lord, my husband has gone and filed this divorce suit at Jorhat, where he resides. So since he is already contesting the MR case and DV case at Hojai, my lord, so I'm praying that this divorce suit may be transferred to Hojai. And my lord, I'm not getting any maintenance, my lord. The father is a tailor. I'm now assisting my father in his tailor shop, my lord. So inconvenience is also there, my lord. For traveling from Jorhat to Hojai, Hojai to Jorhat, my lord.
Heard Mr. S. Nawaz, learned counsel for the petitioner. This petition under section 24 of the Code of Civil Procedure 1908 filed by Simo Mazumdar for transferring of title suit within bracket matrimonial number 101 of 2024 from the Court of Learned District Judge Jorhat to the Court of Learned District Judge Hojai. The learned counsel for the petitioner submits that the petitioner resides at Hojai, wherein she has been pursuing one MR case number.
MR case number 255 of 23.
255
of 23.
255 of 2020.
23, my lord.
2023, wherein the respondent
has appeared and filed written statement.
Respondent has appeared and filed
Written
written statement, and that she is not in a position to pursue the matter at Jorhat, and therefore it is contended that the matter may be transferred to the Court of Learned District Judge Hojai from the Court of Learned District Judge Jorhat. Let notice be issued to the respondent stroke opposite party by registered post and also by usual process within a week from today. List the matter after 4 weeks.
Till returnable date, my lord, proceedings may be stayed, my lord. Otherwise, because it is fixed on 28,
At what is this that proceeding is pending?
my lord, this divorce suit. my
No,
lord.
yes,
Divorce suit is fixed on 28 for appearance and written statement, my lord.
20.
20 of this month, my lord. 20th of August, my
The
lord.
learned counsel for the petitioner submits that the divorce suit number,
Divorce suit number, title suit matrimonial number 101.
title suit matrimonial number 101 of 2024 is fixed on 28th of this month before the court of learned district judge Jorhat for appearance.
For appearance, my lord.
For appearance and submits that till returnable date, the same may be stated. There is accordingly allowed till returnable date. Title suit matrimonial number so and so stands state.
My lord, one submission, my lord. My lord has mentioned MR case number. We have mentioned both MR case and DV case. That may also be.
MR case
And DV case, my lord.
and
And
DV.
DV case, DV case. MR case.
What is the number? DV case number?
DV case number, my lord, is 317 of 23.
317 of 2023.
I'm deeply obliged. my lord.
Item number 3.
May it please your lordship. Lordship is a transfer petition, lordship, filed by the lordship, wife of the respondent, seeking transfer of the lordship means guardianship case number 1/2024, pending in the court of lordship, Learned District Judge Karbi Anglong Diffu to the court of lordship, Learned District Judge Tinsukia lordship. And lordship, the respondent has sought custody of the 2 children, minor children, who are residing with the petitioner lordship in Dumduma lordship. And the respondent is a resident of lordship, Karbi Anglong. And lordship, earlier lordship, the petitioner has filed a 125 proceeding in the court of lordship Tinsukia. And there, despite service of notice, the respondent did not contest, and the case proceeded ex parte, and the order of maintenance lordship was awarded lordship to the both lordship petitioner and both the children lordship. Total amounting lordship 6,500 lordship. That lordship will find at page number lordship 16. The order of maintenance.
We'll consider it later on.
And lordship,
Now, let
apparently-
notice go.
notice lordship may go, but the next date is fixed on 9th of this month for WS in lordship Diffu court. And lordship, the petitioner is lordship residing with her mother, and no any male member is there. Adult male member is there, lordship. And both the children are lordship student of lordship class 6 and class 2 lordship. So she has
No,
to
the other case is pending in which court?
it has been disposed of lordship. The
Disposed of.
maintenance case in
Where?
Tinsukia lordship.
Tinsukia.
And lordship, apparently lordship, as per the lordship section 9 of the guardianship and ward set, this petition could not have been presented in the court of lordship, the full lordship, because it should be filed where the minor children ordinarily reside, lordship, as per section 9.
Okay, we'll consider it.
Lordship, at least the lordship, I am praying for lordship staying of the proceeding lordship before the court below lordship. Otherwise, lordship, also distance is lordship around 375 kilometers. Lordship.
Heard Mr. N. Hassan, learned counsel for the petition. This petition under section 34 of the Code of Civil Procedure is preferred by Srimati Nasima Khan for transferring of Miss Guardianship case number 01 of 2024 pending before the Court of Learned District Judge Karbi Anglong Diffu to the Court of Learned District Judge Tinsukia. Mr. Hassan, learned counsel for the petitioner, submits that the petitioner is living in her parental abode at Dumduma, and the respondent, Mohammad Jamil Khan, who happens to be her husband, filed a guardianship, Miss Guardianship case number 1 of 2024 before the Court of Learned District Judge Karbi Anglong Diffu. Mr. Hassan submits that the petitioner resides with her mother at Dumduma, and there is no male member in her family, and it is not possible for her to attend the court at Karbi Anglong Depot by by traveling 370
5
kilometer, 5 kilometer, and besides, is there any provision in the Guardianship Act that the petition should be filed before the court where the
Yes, where
Minor is-
the minor child resides. It is
Where?
lordship, section 9.
9?
Section 9 lordship. May I read lordship? First
Yes.
clause. If the application is with respect to the guardianship of the person of the minor, it shall be made to the district court having jurisdiction in the place where the minor ordinarily resides. In this. In this
Again,
case,
you
the
take
minor
up, referring to section 9 of the Guardianship Act.
guardianship and what's it?
Guardianship and Wards Act, Mr. Hassan submits that as per section, as per said section,
9 subsection 1.
subsection 1, the proceeding seeking custody of the minor child has to be filed in the court in whose jurisdiction the minor resides, ordinarily resides. And on that count also, the case has to be transferred to the court of district judge, learned district judge Tinsukia from the court of learned Karbi Anglong, district judge Karbi Anglong Depot. The submission so advanced by Mr. Hassan needs further consideration. At this stage, notice we issued to the respondent returnable in 4 weeks, is to be taken by registered post and also by usual process within a week from today. And till returnable date, further proceeding of Miss Guardianship case number 1 of 2024 pending before the court of learned district judge Karbi Anglong Depot stands state.
Deeply obliged.
Item number 4.
May I please, Your Lordship? Sir, I am the plaintiff. I have filed a suit declaring that is a land measuring 2 kathas 8 lesas is wrongly recorded as khas in Patian number 1, and that is admitted by the state that the land has been as khas land. We got a decree, and therefore we have filed an execution petition. It took 13 years to finally dispose of the execution petition, Lordship. The learned executing court refused to execute the decree on the ground that decree has been already satisfied. But the illegality is that the learned trial court have passed the decree in respect of 2 kathas 8 lesas to Karekit in my name. That has been wrongly recorded as khas land, Lordship. In this case, Lordship, I have already got a decree, a permanent injunction has been granted. In this case, Lordship, notice will be issued and call for the record, Lordship, because in the record, the state has submitted so many as 10 to 12 report regarding the land. Sometimes they say that the land has been recorded as khas, sometimes that say that the land has been separated from a different dark, so therefore a record is necessary, Lordship.
Heard Mr. D. Coletta, learned counsel for the petitioner, and Madam K. Fukon, learned counsel for the respondent number 1 and 2. In this civil revision petition under section 115 of the Code of Civil Procedure, the petitioner has put to challenge the correctness or otherwise of the order dated 22/4/2024 passed by the learned civil judge within bracket junior division number 2 Dhuguri entitled execution case number 35 of 2001, and thereby dispose of the execution proceeding arising out of judgment and decree dated 29/6/2001 passed in TS case number 331 of 1995 on the ground that the decree has been fully satisfied. Where is the petition and the documents placed on record? Let notice be issued to the respondents, returnable in 4 weeks. However, no formal notice is required to be issued since Ms. K. Fukon, learned counsel, appears on behalf of both the respondents and received notice. However, extra requisite copy of the petition will be furnished to her during the course of the day. Call for the record. Recessal call for the record from the learned trial court. Please the matter after 4 weeks.
Obliged.
Item number 5.
Yeah, please, madam.
My lord, here the petitioner before lordship here the defendant number 1 and 2, my lord. The plaintiff, my lord, filed a suit. My lord, their case is that they were possessing the land. And my lord, in the year 2003, they have entered into an agreement with the Tinsukia Development Authority that the Tinsukia Development Authority will sell the land to the plaintiff, my lord. But in the year 2017, they came to know that the land was already sold to defendant number 1 and 2, my lord. And the defendant number 1 and 2 has, when come to take the possession of the land, they come to know about the sale deed. So they have filed the suit challenging the sale deed in favor of defendant number 1 and 2, as well as my lord, for a direction to the Tinsukia Development Authority to execute the sale deed, my lord. Initially, my lord, the injunction was not granted. The court has come to a finding that since the possession is disputed, so the court has initially granted only a status quo to preserve the suit land, my lord. Then, my lord, after hearing all the parties, my lord, on my lord 12/6/2024, a status quo order was granted, my lord, to preserve the suit land. And my lord, on 13/6/24, there is another miscase, my lord, although it was heard together, but on the next day, my lord, order was passed to repair. There are some abandoned houses, my lord, to which the plaintiff claimed that they were, my lord, in a depleted condition, so they have paid for repairing of that house. So 12/6, my lord, injunction was passed, and 13, my lord, order was passed to repair that houses, my lord. I am challenging that order by which, my lord, the repairing was allowed, my lord. My lord, before going to into an order, I have annexed the photograph of the houses, my lord. Lordship may kindly come to page number 71 and 72, my lord. Page 71 and 72. Well, these are the photographs which is produced by the plaintiff, my lord. Well, these are abandoned houses, my lord. Only since a status quo order was passed and they are not in possession, my lord, they have filed the petition for repairing, my lord. And although it was heard, but the order was not passed on both the petitions on the same day, my lord. And my lord, since there is no separate objection was filed in this miscase, my lord, so the court has passed an order by granting the order of repair, my lord. But if lordship may go through the, my lord, this photographs, my lord, this is clear that these are abandoned houses, my lord.
So Annexure G is the impugn order?
No, my lord, Annexure G, my lord, page 69.
Yes.
Yes, my lord. And the relevant will be page 70, my lord, paragraph 5, my lord. Page 70, paragraph 5. May I read, my lord?
Yes. No, the order is very much clear.
Yes.
Petitioner can repair it by maintaining the order of status quo.
Yes, my lord, but they are not in possession, my lord. And my lord, from photograph, these are, my lord, all abandoned old houses, my lord. There is no scope of repair, my lord. Only by this order, they want to enter into the suit land.
Heard Mr. A.K. Gupta, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, read with section 115 of the Code of Civil Procedure, is preferred by the petitioner. Preferred by two petitioners, namely Srimati Reena Moni Duara Gohai, alias Reena Gohai, and Sri Jitul Chandra Gohai, challenging the correctness or otherwise of the order dated 13/6/2024, passed by the learned civil judge senior division Tinsukia in Misje case number 138 of 2023, arising out of Misje case number 90 of 2018, in the title suit number 47 of 2018. It is to be noted here that by impugn order dated 13/6/2014, the learned trial court had allowed the respondents to repair the house situated within the suit premises suit premises. At the at the time of passing the order of status quo. Mr. Gupta, learned counsel for the petitioner submits that the suit land is not in the possession of the respondents, and on the strength of the aforesaid or on the strength of the impugned order, they want to enter into the suit premises. Suit premises. And therefore, Mr. Gupta contended that the order dated 13/6/2024 maybe. What is your prayer here?
For set aside the order dated 13/6/24.
For setting aside the order dated so and so so and so. Let notice be so to the respondent returnable in 4 weeks is to be taken by registered post with AD and also by usual process within a week from today. Call for the scanned copy of the record. Until returnable date, further proceeding.
No, my lord,
Okay.
my lord, I'm only praying for a staying of this order. My lord, let the proceeding go on.
No,
Yes.
operation of the impugned order dated 13/6/2024 stands state.
Okay.
Past tense, so miscast no so and so.
Okay.
Item number 6. May I please, Your Lordship? Yes. In this case, the petition of before your lordship is the defendant number 1 entitled suit number 16/21 is pending in the learned Court of Civil Judge Junior Division, Gosaigaon. The petitioner filed in this petitioner being a defendant filed two petitions for amendment of the written statement as well as leave of the court for producing some documents. By impugned order dated page 18 and 3/2/2024, both the petition rejected. And petitioner before your lordship has filed two CRP IO. One earlier was rejected, listed in your lordship, listed. And the honorable court passed order, I have passed this order. Two petition filed on same day, two petition was rejected. I have filed two CRP IO. One already, notice has been issued and further proceeding has stayed. And this petition is for amendment of the vacancy. Notice, madam, we should add this state.
Heard Mr. S. Islam, learned counsel for the petitioner. In this petition, under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, the petitioner, namely Mohammad Surat Ali SK, has challenged the correctness or otherwise of the order dated 2/3/2024 passed by the learned Civil Judge Junior Division, Gokaigaon in Miss within bracket Z case number 70 of 2023, arising out of title suit number 16 of 2021. It is to be noted here that by the impugned order dated so and so, the learned trial court has dismissed the petition.
Page 89, 84.
Page
84. Annex 30. Amendment of the written statement. Right. 84. Annex 30.
For amendment of the written statement. Where is the petition and the grounds mentioned therein? Let notice be issued to the respondent returnable in 4 weeks. Is to be taken by registered post and also by usual process within a week from today. Call for a scan copy of the record from the learned trial court. Place the matter after 4 weeks. The till returnable date, further proceeding of title suit number 16 of 2021 pending before the Court of Learned Civil Judge, Gokaigaon, Stansi State.
Number 7.
May I please, your lordship? My lord, the petitioner before your lordship has challenged the order dated 14/6/2024. My lord, the petitioner, being the plaintiff, my lord, filed a suit for a specific performance of contract. Now, my lord, an agreement was entered into for purchase of 2 kathah 10 lecha of land. And so far the respondent is concerned, my lord, entered into that agreement by way of a registered sale deed, agreement, my lord, that your lordship will be pleased to find at page number 34, my lord. Thereafter, permission was obtained for execution of the sale deed, my lord, and that is at page number 44. Deputy Commissioner granted permission to execute the sale deed. On non-performance, my lord, a notice was sent and thereafter the suit was filed. Now, my lord, after tendering of the evidence in the suit, I had filed an application under order 16 to call for the sub-registrar who had registered the sale deed, my lord, having the agreement for sale, and also a person from the office of the Deputy Commissioner to prove that sale permission, my lord. That application is rejected, and your lordship will be pleased to find the order at page number 81, my lord. Impugn order at page number 81. It's a lengthy order, my lord. May I read, my lord, that order?
Yes. 14/6/2024.
My lord.
Order dated 14/6/2024.
14/6, yes, my lord. 14/6, in the Miss case also the order was passed, and in the title suit also the order was passed. Title suit is fixed for argument on 9/8, my lord, day after tomorrow. And my lord, if I can take your lordship to the order at page number 84, my lord, and its typed copy as page number 83. Typed copy at page number 3 in the form of annexure 5, my lord. Plaintiff is represented and defendants are absent without any steps. Learned Advocate Commissioner has submitted the report that the defendant did not contact for her cross-examination of plaintiff witnesses. Let the report be kept with the case record. The case shall proceed ex parte against the defendant. Learned counsel for the plaintiff has prayed for closing the evidence. My lord, it ought to have been for giving of the evidence by the defendant, but the entire matter is closed, my lord, by that. And I am against the order dated 14/6, my lord, because I have not been allowed to prove those documents which I had submitted in the form of the certified copy. 3 documents, my lord. My lord, at page number 81, your lordship will be pleased to find in paragraph number 2, if I am starting.
84 is the order dated 14/6/2024.
14/6/2024.
Yes.
Yes. It is at page number 81, my lord.
Page number?
81. 81, my lord. 81.
Yes.
The date is fixed today for passing of the order on the petition number 2415 filed by the petitioner plaintiff under order 16, rule 6, 7, and 14, read with section 151, praying for permission to summon the official witnesses, that is the circle officer of North Guwahati Revenue Circle, in order to prove the Jamabandi, which has been marked as Exhibit 1, Senior Sub-Registrar Sadar Kamrup, Amin Gaon, for proving the agreement for sale, an agreement for sale which has been marked as Exhibit 2, Office of the Branch of the Sale Permission of Office of the Deputy Commissioner Kamrup for proving the sale permission, and the branch manager, Bank of India, Abhaipur branch for proving the updated passbook or statement of the bank account of the petitioner. The learned counsel for the petitioner has submitted that the aforesaid documents and the evidence of official witnesses are necessary for proving the case of the plaintiff, as well as for determining the real issues between the parties, and has prayed for allowing the petition. OP number 1 has not filed written objection. in this case, WO in this case, the learned counsel for the OP number 1 has argued and submitted that the petition is not maintainable and has prayed for it to be rejected. I have heard both the parties and perused the case records. On such perusal, it is seen that the plaintiff has entered the names of the Senior Sub-Registrar Kamrup Amingaon, Circle Office Officer, North Guwahati Revenue Circle, Branch Manager of Bank of India, Abhaipur Branch, as the witnesses to be examined by the plaintiff in his list of witnesses. In the list of witnesses, my lord, I had already submitted these names, and they are the official witness, my lord. However, the plaintiff has, along with the prayer for summoning the official witnesses in order to prove the documents, which has been marked as Exhibit 1, that is the Jamabandi of the shoot land, deed for argument, agreement for sale. Here argument is written, it is agreement for sale, which has been marked as Exhibit 2, sale permission number, which has been marked as Exhibit 3, and the updated bank passbook, which has been marked as Exhibit 9. The plaintiff has submitted the Xerox copies of the Exhibits 1, 2, 3, and 9. However, the plaintiff has failed to plead in his pleading why the primary evidence of the documents have not been filed by him. The secondary evidence of documents are allowed to be filed and exhibited and proved only when the original of such documents have been accounted for, and in the absence of such pleadings, the secondary evidence of the documents cannot be submitted. The plaintiff has submitted the Xerox copies of the Jamabandi, agreement for sale, and sale permission, and has prayed to examine the official witnesses to prove the same. However, the certified copies of such documents have not been filed, and originals have also not been accounted for. Necessary groundwork for adducing the secondary evidence has not been laid by the plaintiff, and hence, in such a situation, official witnesses, that is the Circle Officer Kamrup, Senior Sub-Registrar Sadar Kamrup, and officials of the sale permission branch cannot be summoned to prove such documents alone. Moreover, the name of the officials of the sale permission branch of the Office of the Deputy Commissioner Kamrup has also not been mentioned in the list of witnesses. The plaintiff has prayed to summon and examine the branch manager of the Bank of India, Abhaipur branch, in order to prove the dishonor of the check issued by him. However, as it is apparent from the case record and in the pleadings of both the parties, it is an admitted fact that the checks were dishonored owing to the mismatch of the signatures of the petitioner, and hence the admitted facts need not be proved, and necessity lay examine the summoning the branch manager, Bank of India, Abhaipur branch does not arise. The petition lacks merit and is therefore rejected. So, order. My lord, so far the sale permission is concerned, it was a time when some clerk was there who has, put the initials. I can take your lordship to order, this page number 44 to better appreciate that. Page number 44, that is the sale permission, my lord. No clerk has put any signature, so how can I give the name of the clerk in that list, my lord? And clerks are getting changed. So I can only ask the authority to come and depose. My lord, this is page number 44, is the permission granted by the Deputy Commissioner for the purpose of execution of the sale deed. And before that, if I can take your lordship to page number 34, my lord, that is the certified copy of the agreement for sale. Page number 35 is the first page. Page number 36, my lord, is the agreement of sale.
Have you made any such averment in your client?
My lord?
Have you made any averment in that respect in your client?
In my plane? Yes, my lord. All those are...
No, that you could not name the witness because no name is mentioned in the said exhibit.
No, agreement witnesses are there, my lord. That I don't want to call. I want to simply call the person in the form of the Senior Sub-Registrar who has registered this agreement for sale, and the person from the Office of the Deputy Commissioner who has issued this, because it is, my lord, computerized one. Computerized one. And he will come with the official record where the numbers are mentioned. My lord, the learned court has totally not applied the mind as regards the documents are concerned. And the case is fixed, my lord, for argument. Argument, if I can take your lordship to page number 83, that is the typed copy of the order passed in the title suit. And it is fixed on 9/8/24, my lord.
Page number?
83, my lord. 83, my lord. An actual file. '84 is the handwritten order. I have typed, I have got it typed. Page number 84 is the handwritten order.
Heard Mr. Sattar, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner, Sri Dipankar Boru, has put to challenge the correctness or otherwise of the order dated 14/6/2024 passed by the learned civil judge senior division Kamrup at Amingaon in Mizze case number 120 of 2023 and entitled suit number 13 of 2024. No, 2020, whereby the learned trial court was pleased to reject the application filed by the petitioner struck plaintiff under order
16, my lord.
under order 16 rule 6, 7 and 14 with read with section 151 of the Code of Civil Procedure, and thereby denied to issue summon to the official witnesses in the title suit. Peruse the petition on the documents placed on record and also peruse the impugned order dated 14/6/2024 passed in Mizze case number 120 of 2023 and entitled suit number 13 of 2020. Let notice be issued to the respondent returnable in 4 weeks is to be taken by registered post with AD and also by usual process within a week from today. Call for the scanned copy of the record from the learned trial court. Mr. Sattar, learned counsel for the petitioner, submits that the learned trial court has fixed the matter on 9/8/2024 for argument. And therefore, Mr. Sattar submits that till returnable that the impugned order dated 14/6/2024 passed in title suit number 13 of 2020 and the order dated 14/6/2024 passed in Mizze case number 120 of 2023 may be stated returnable that. Having considered the submission of learned counsel for the petitioner and also considering the facts and circumstances of the record, the impugned orders dated so and so in passed in Mizze case number so and title suit number so stands to state. Release the matter after 4 weeks.
Pleasure. Pleasure.
Number 8.
Under this contempt case has been filed for Alice violation of order at page 9. MSC appeal filed by the Oriental Insurance Company and operative page paragraph 21, page 14. That claimant number 2, wife of the deceased. This appeal is partly allowed. Compensation and award is modified as decided above. Messrs. Oriental Insurance is directed to deposit this change to the savings account of the wife. Then page 15. Is the contempt case maintainable against non-implementation of the order in MSC cases? Maintainable. They have to pay, my lord. Otherwise, I have no relief, my lord. How can I get? No, you can instant Bakije proceeding also. I have no idea, man. So far as my lord, for non-implementation of the order, immediate remedy is to file contempt petition. They have filed the appeal, they are very much aware about the judgment. No, some provision is there in the MSC, motor accident claim. No, motor vehicle act. You are not aware. You go through it. Let us fix another date. Sort that, Monday, next Monday. Heard, Mr. Hanson. And? Learned counsel for the petitioner. Yes, right for. By Mr. Sharma, list the matter on Monday.
On 12 August. Items for admission, item number 9.
Future adoption.
Who is a standing counsel for the NFL? You.
My senior, my lord. BK Das, my lord. I am appearing.
So where is the record of the state officer?
We have received, my lord.
You have not received.
Received, my lord.
Received.
I thought we taken up, my lord, next, another, my lord.
When?
Next, another, my lord. My senior is another court, my lord.
When to be listed?
Next thing, my lord.
Next week. Okay.
On 19th, Lord, Monday,
19.
19th.
Heard, Miss.
8 Alukar.
Learned counsel for the petitioner and Mr.
It's been, my lord.
Learned counsel appearing on behalf of Mr.
BK Das.
DK.
Das.
DK Das. BK Das,
BK
learned
Das.
counsel for learned standing counsel for the NFL. Mr. So-and-so, learned counsel appearing on behalf of Mr. BK Das, learned standing counsel for the NFL, submits that he has received a record of the state officer. And as Mr. BK Das is busy in another court, he prays for listing the matter next week. Here is accordingly allowed. Recess will list the matter on
19.
19.
Item number 10.
Under section 384 of Indian Succession Act, I have challenged the impugned judgment and order 54 and kindly see page 73. While deciding the issue number 1, paragraph 27, in view of the above, it held that instant definitive grant of is not maintainable because no executor is appointed under the will in question, and legatees have not paid for letter of evidence. Regarding maintainability of the probate case admit and this rejected the claim of the petitioner for obtaining probate. So your petition for issuing probate stands dismissed. Heard, Mr. K.R. Padgiri, learned counsel for the appellant. This appeal under section 384 of the Indian Succession Act 1925 is preferred against the judgment and order dated 24/4/2024 and the decree dated 4/5/2024 passed by the learned additional district judge Barpeta. in title suit, which will make it probate case number 02 of 2022, wherein the application filed by the appellant under section 276 of the Indian Succession Act, praying for granting probate of the will dated 23rd to 2003 was dismissed. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and decree dated 24/4/2024 and dated 4/5/2024 respectively. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Register shall call for the record from the learned trial court. Please the matter after 4 weeks.
Apply.
Item number 11.
May I please, your lordship?
Yes.
This appeal has been filed by the insurance company on the position of quantum,
Quantum.
lordship. Lordship, this was a central government employee, and due to the accident, the central government has paid him a accuracy payment of rupees 25 lakhs. Our concession is that this 25 lakhs should be has been deducted while awarding of this compensation by the trial court. Our second point is lordship, income tax was not deducted from the salary of the by calculation of the loss of dependency.
Yes.
Lordship, tribunal has awarded rupees 66 lakhs 71,000 rupees 120. Our concession is from that the 25 lakhs which the disease has received basically on the due to the accident, specifically for the accident, that should have been deducted. And the income tax should have been deducted during the calculation of the
So what are the grounds you have mentioned in your petition?
lawsuit. The ground I mentioned, my first ground was the income tax was not deducted during the calculation of the loss of dependency lawsuit. Second ground is lawsuit, there are two vehicles, they were head-on collisions. So both the vehicles should be contributing negligence of the both the vehicles should be held. This is admitted fact. The IOS also admitted. The IOS it is a head-on. The second is the ex gratia amount of 25 lakhs should have been deducted. Otherwise, it will reduce in double gain for the claimant loss. These three are the one basic ground of appeal lawsuit.
No, whether you have raised the issue of composite negligence before the member?
Lawsuit. The judgment also the composite negligence was discussed. Head-on collision it has come in the judgment lawsuit. The IO has during the IO it was during the process IO said I don't know for whose negligence the accident occurred because I have not seen the accident. head-on is admitted fact.
Have you laid any evidence?
Lordship, no evidence from us.
You have not laid any evidence.
On that
Then
particular,
on what basis it can be determined that there was composite negligence?
Lordship, the claimant himself in her evidence stated the disease has
No,
been.
merely because the vehicle was coming from front side, it does not mean that there was composite negligence.
Lordship, there are some Supreme Court judgment, Lordship, I can say, which.
Pardon?
There are some Supreme Court judgment, Lordship, which say the head-on accident implies composite, contributing negligence, head-on, not composite, contributing.
Whether the record has been received?
No, sir, it is listed for the first time, the appeal.
Pardon?
Appeal has been listed for the first time. Record has to be called.
For the first time?
First time.
No, no.
Last time we are absent, Lordship.
Acha.
They were
Okay.
delayed, Lordship, the delay was
Okay.
conduct, then it is been listed for.
Okay. Third, Mr. Your good name?
Yeah, Acharya.
Learned counsel for the appellant.
Right.
Appellant, New India Insurance Company Limited. And Mr. You,
I'm for claimants, my lord, 1 to 4, my lord. K.I. Mazumdar.
K.I. Mazumdar.
K.I.
K.I. And also heard Mr. K.I. Mazumdar, Learned Counsel for the respondent number 1, 2, 3, and 4. This appeal under section 173 of the Motor Vehicle Act 1988 is directed against the judgment and award dated 11/10/2023 passed by the Motor Accident Claim Tribunal, Dhoburi, in MSC case number 222 of 2017. It is to be noted here that by impugned judgment and order dated so and so, judgment and award dated so and so, the learned tribunal has directed the appellant to pay a sum of rupees 66,71,120 rupees. So in the order dated, in the impugned order dated so and so, it has been reflected that subject to payment of tax. You come to paragraph number 28 of the judgment.
Subject to payment of the tax if any.
Yes.
Subject to- If any.
Yes.
Lordship, but in the calculation part, later in the page number 28. The interest, 7% interest has been calculated on the whole part. No tax was deducted. The calculation. Lordship,
No, tribunal is not supposed to deduct the tax.
Lordship, during the calculation of loss of deficiency, the tribunal is supposed to take into consideration the tax, deduct the tax, then come to a finding of the total per month income, then.
No, whether all the documents were available before the tribunal.
Lordship, yeah, basically available, the employees come and submit this evidence to the employer.
So is there any decided case on that point?
Lordship.
That tribunal has to calculate the tax amount, income tax?
Lordship, I don't have it today, Lordship, but they are leading cases. Leading cases. Total income is the income for calculation is the total income minus income tax. The income that should be considered for calculation of loss of deficiency is the income minus income tax and profession tax if there is professional tax. Lordship, that is in the pronounced city statement judgment. Lordship may be aware of pronounced city statement.
Yes.
Here also it is reflected. The income is the total income minus tax.
No, that's all right. Provision is there, but who will deduct the tax?
The
Who will calculate it?
Tribunal should have calculated, doing the calculation. Doing the calculation of loss of income, they should have first of deducted the tax amount, then come to a income of the.
Let us do one thing, let us fix it on Monday, you produce the judgment, we will see. What is the relevant provision? As spread for by Mr.
Yeah, sir.
Learned counsel for the petitioner, no appellate. Recess shall list the matter on Monday.
Item number 12.
Wait, please, your lordship. Lordship, this is an MSc appeal, lordship, filed by the insurance company, lordship. Basically on quantum, taking into the effect of contributory negligence of the deceased person, lordship. Because the accident took place between two vehicles coming from the opposite direction, lordship. So that was not taken into account, lordship, by the learned member. Lordship may kindly see page number 17 of the main appeal, lordship. There are 13.
Yes.
Because if head-on collision between two vehicles, lordship. If there is no other evidence, presumption has to be taken that this was a head-on collision and negligence should be apportioned between two vehicles, lordship.
No, that was your submission. Is there any evidence?
Lordship, because the pleaded fact and the evidence examined by the claimant side, there was no evidence that our vehicle had gone into the wrong side and dashed the vehicle ridden by the deceased person. There was a statement that collision between two vehicles coming from the opposite direction. And lordship, I am referring to the judgment of Bijoy Duggar, lordship, wherein it has been stated that when two vehicles come from the opposite direction and there is a collision, presumption should be drawn that negligence was of both the vehicles.
Is that judgment available with you?
Right now, lordship, I don't have the judgment.
Produce it on Monday.
Lordship,
As spread for by Mr.
D. Colita.
D. Colita, learned counsel for the appellant. Recess shall list the matter on Monday.
So items for bail hearing, item number 13.
Please, your lordship. Your lordship, this matter may be adjourned for the timing, your lordship. Again, counsel is relaxing another court.
Item 14.
Here is a case for 13 an application for under-type prisoner. And my lord, some crucial issues are there, which I would like to go before lordship. Prior to that, lordship, straightway, I would like to come to the FIR, my lord. FIR contained in page 14. One four.
This is second bail application before this court.
No, it's the first application. Earlier it was raised before the, my lord, learned trial court below. That was rejected. They have to proceed.
This is first application before this court. Okay. এখনতো প্ৰথম এপ্লিকেশন নহয় ইয়াতে এখনতো মাৰ্ডাৰ কেছ এটো এৰিয়াতে যাব
Earlier, lordship only taken up this matter where CD has been called for.
When?
On last occasion, once this matter was placed before lordship, then lordship passed in order to call the scan copy of the CD.
On 16/7/24.
এইটো কাৰণে
If there is no any earlier rejection order, Lordship,
There is no
it may go to, it will go to the other bench, Lordship.
Other Lordship may also, yeah, there is no problem since listed.
Pardon?
If Lordship please to, because some crucial issues are there, very important issue about speedy trial article 21, the recent 18 July 2024 judgment passed by the Supreme Court, where minority elaborately discuss the rights of the under-trial prisoners, my lord. I would like to place their citations and
No, Mr. Samoria, you see, merely because I have called for the scanned copy of the record, would not to be, would not to have been placed before this court because another bench is taking up the matter.
I leave to your lordship for that consideration.
Yes, Mr. Loskar, what to do?
That can be
Otherwise,
done,
if
Lordship.
Lordship
Before
please to,
appropriate bench, it may be sent.
Pardon?
Before appropriate bench, Lordship. As
But
per the
in another application arising out of the same FIR, I have disposed of one application.
that case procedure.
interconnected because there are lots of accused are there. For Lordship, here this
For
matter.
that reason,
other-
it may be
Lordship-
listed, Lordship. For that reason, it may be listed before you, Lordship. Nowadays, Lordship.
Yes, I have
Accused are
gone through the scan copy of the record. So search it has been submitted here. When he was arrested,
My lord, he was arrested on my lord that 20,
15/10/23.
when?
15/10/23.
Okay, then after some time.
Query number 15.
Make please, Your Lordship. It's a second application, my lord. Your Lordship will find the FIR, my lord, at page 11, my lord.
So CD received, Mr. Loskar?
Receipt, Lordship.
Yes.
My lord, may I read out the FIR, my lord? With due respect, I beg to state that I am an inhabitant of village so and so. On 10/3/24 at 9:20 AM, the below mentioned accused number 1 with other accused person were closing the road whereby you used to come out from our house. My father, namely so and so, when he was asking about the closing the road, then the accused number 1 suddenly assaulted by a bamboo stick on the neck of my father. As a result, my father instantly sat down on the ground. Thereafter, the other accused person also punching. Consequently, my father got unconscious and fall down on the ground. And it was instigated by the accused number 2. Thereafter, I came from my house and observed that my father was lying on the ground. Then I started hue and cry, and after hearing my screaming, villagers, by arriving the place occurrence, called 108 ambulance and took my father to the Dhubri Civil Hospital in an unconscious condition, but the doctor, after examining my father, declared him dead. Well, here I am, the petitioner before your lordship is, my lord, the accused number 2, my lord, Shahadat Ali, my lord. Now your lordship rejection order, my lord, at page 21, my lord. My lord, the next page, my lord, page 22, my lord, paragraph 5, my lord. The prosecution's case, my lord. My lord, on the other hand, by producing the case diary before this court, Mr. Gogoi learned APP submits that the witness examined so far indicates the complicity of the present applicant with the offense alleged in the affair. Mr. Gogoi, referring to the PM examination report, submit that the father of the informant suffered demise due to injuries sustained over his neck, and that the injuries were anti-mortem in nature caused by the blunt force impact. Mr. Gogoi further submits the investigation is still going on, and only one accused has been arrested so far here in the case, and the rest of the accused are yet to be arrested, and therefore it is contented to dismiss the petition. Malab, my only instruction from the client is that, Malab, I was there, my lord, when the accused number 1 inflicted the injury, my lord. Well, I did not participated in that process.
No, allegation against you is that
Instigation,
instigation.
my lord.
Hmm.
Only, and the case is registered under 143 and my lord 302, my lord. The rest I leave it to the diary, my lord.
Here was a quarrel lordship, thereafter lordship, as per CD lordship. First, the quarrel was made between these persons, all these persons lordship. He was present, this petitioner was also present lordship. And later on lordship, that once Subur Ali has inflicted the
Sabur
Ali lordship. Sabur Ali has assaulted him with a bamboo stick lordship. That is there from the witnesses and
So what is the ground for filing this second
The
application?
second application, my only ground is that, my lord, I was there in that assembly, my lord, but I did not participate, my lord, in inflicting the injury, my lord. Whatever has been done by, it was by the accused number 1, my lord, who got arrested, my lord, and he was afterwards, my lord, he was released on bail, my lord.
That aspect has already been considered
My lord, that part, my lord,
because
whether I-
we cannot review the order.
no, I am not on only instigation, my lord. I have not instigated, my lord. That much, my lord.
No, but the observation of the court is that IO has collected sufficient and incriminating materials against you.
I will take my video.
How can you challenge that finding before the same
Yeah,
court?
but that was the, if diary says so, my lord, I have nothing to say. But it was the submission made by the PP, my lord. That the,
No, operative part is paragraph number 7.
Yes, yes. Only my instruction is that I have not instigated, my lord. That much, my lord. I have nothing more to submit, my lord. Otherwise, case diary will speak, my lord. And by this time, my lord, the investigation also progressed, my lord. Sufficient. I think so.
Heard Mr. NZ Dr. Learned Counsel for the applicant and also heard Mr. PS Locker, Learned Additional PP for the students. This application under section 430H30C is preferred by applicant Sahadot Ali, who has been apprehending arrest in connection with Dhuri PS case number 73 of 2024 under section 143 302 IPC. Be it mentioned here that the above noted case has been registered on the basis of an FIR lodged by one Taizuddin SK on 11/3/2024. The essence of allegation made in the FIR is that on 10/3/2024 at about 9:20 AM, on the instigation of Sahadot Ali, Najibul Islam, Hasibul Islam, Jasus Sheikh, Nazira Bibi, Ali Hussein, Safiqul Islam alias Mintu and others, one Sabur Ali, closed the road being used by the informant for going out of his house. Then the father of the informant, Muhammad Sunaullah Sheikh, inquired about losing of the road from Sabur Ali, and then as per direction of Sahadat Ali Sabur Ali assaulted his father with stick on his neck. As a result, the father of the informant sat down on the ground, and then other accused person also administered blows with fist on the person of his father, and consequently his father became unconscious and fell down on the ground. Thereafter, he raised alarm, and then the nearby villagers arrived there and taken his father to Dhuburi Civil Hospital, where doctors declared him brought dead. Mr. Dr. Learned Counsel for the applicant submits that the applicant did not take part in the said offenses, and the only allegation against him is that he has instigated the accused number 1. And further, Mr. Dr. submits that after registration of the FIR, several months elapsed and the IO got sufficient time, and therefore Mr. Dr. has contended to allow this petition. Whereas Mr. P.S. Locker, learned additional PP, has produced the case before this court and some that. What is the stage of investigation?
Lordship, one person that Supurali has been arrested, Lordship.
That investigation is going on, and the IO has collected materials against the applicant, and therefore it is contended to dismiss the petition. Having heard the submission of learned advocates of both the parties, I have carefully gone through the petition and the documents placed on record, and also perused the case diary with the assistance of Mr. Locker, learned additional PP. It appears that this is the second anticipatory bail application preferred by the applicant, and the first one being AB number 955 of 2024 was dismissed by this court by order dated 6/6/2024 after perusing the case date. It is well settled by catenary decision of Honorable Supreme Court that second bail application is maintainable only on the ground of change of circumstance in favor of the applicant petitioner. Here in this case, Mr. Dr. Learned Counsel for the reference in this case can be made to the decision of Honorable Supreme Court in Kalyan Sarkar versus Papu, and also A. Raja versus State of Tamil Nadu. In the case in hand, Mr. Dr. Learned Counsel for the applicant has failed to show any change of circumstance in his favor after dismissal of the first application on 6/6/2024. Though Mr. Dr. submits that after registration of the FIR, several months elapsed and the IO got sufficient time for investigation, yet the said ground to the considered opinion of this court cannot be a change of circumstance in favor of the applicant. Moreover, the issue raised by Mr. Dr. Learned Counsel for the applicant, that the applicant had not instigated the accused number 1 to assault the deceased, yet this court in the order dated 6/6/2024 has recorded a clear finding that the IO has collected sufficient incriminating materials to show the complicity of the present applicant with the offense alleged in the FIR. That being so, therefore said, issue cannot be raised before this court again. Further, it appears from the case that investigation is going on, and there is sufficient materials to show the complicity of the applicant with the offense alleged. In the result, I find no merit in this application, and accordingly, the same instance of this case there will be returned.
I am applying.
I am the respondent, plaintiff. They took the adjournment without my knowledge and consent.
We usually put a question whether you have informed the other side. The answer is yes.
Other side did not inform me that they took the adjournment. Lordship, kindly see the injustice. I have
Not
prepared the-
injustice, it is the misleading statement by the council.
So,
And there is no point for this court to disbelieve the statement made by the council because you were the officer of the court.
no, my lord, at morning they have mentioned it, we did not know. Because at morning,
Hmm.
they should have obtained it, because they are the
So
they are
when the next date is fixed?
39th.
After 2 weeks.
After 2 weeks. Okay, you consult the other council.
My lord,
Only
my lord,
then we can prepone.
my lord, may I request you, Lordship, maybe taken up on Monday, Lordship,
No, cannot.
then I will,
You inform the other side. If the other side agrees, then we will fix it Monday.
other side is fleeing, he is not traceable. The other side was his
Sorry.
duty. It was his duty to inform the.
Sorry,
council
next
of the-
item, call it.
Council of the respondent, my lord.
Item number 16.
All right, my lord, I will mention it tomorrow. I will, tomorrow I will mention the case, my lord.
You can do whatever you like.
No, my lord, I am all my helpless, my lord. You kindly see, Lordship. The party is suffering.
Happy, your lordship, the conducted council is on legs, lord. Kindly pass over for timing. Mr. Ray Ahmed will argue this case.
But the notice was served upon the respondent.
Chief, I am appearing at the regular council.
You were
Start
appearing?
proceeding.
Acha, okay.
As per my instruction.
Item 17.
He was called for my.
Yes, Locker, CD receive.
He did not receive proceedings. We have been received.
You are on interim.
My lord, I have appeared before the IO.
Mr. P.S. Locker learned additional PP submits that he has not received the case diary. Accordingly, it is provided that Mr. Locker shall produce the case diary before this court on
Interim assembly.
As interim.
On 21st August.
21st. Till then, interim order dated 27/6/2024 is then extended. From which PS the CD will come?
Hanga government.
Pardon?
Hanga government.
Short date, next week,
14.
14.
14.
14th of August.
Okay. Items for hearing under Order 41, Rule 2 of CPC. Item number 18.
My lord, your lordship would be pleased to see order dated 26/6/2024.
Have you filed the affidavit?
Yes, my lord, I have filed. So, my lord, matter is like this. I raise a question of res judicata, my lord. That learned lower appellate court, on the point of res judicata, my appeal was dismissed. So, my lord, I raise this point as a substantial question of law. Then your lordship said that you place the judgment of the original suit
another shoot, my lord. So, my lord, your lordship would be pleased to see the additional affidavit, my lord. Judgment at page 85. So your lordship would be pleased to see, actually, I was not party there. I was not party. So if point of res judicata is to be taken, my lord, it should be between the same parties. That is my point. Your lordship would be pleased to see that my name is not there. It is defendants are Jamaluddin, Abdul Kader, Abdul Haran, Mujibur, Monser Ali, Jolil, etc. my lord. But my name is, my lord, Rohizuddin Mondol. So Rohizuddin Mondol was not party there. So that is why, my lord, I raised the point that lower appellate court committed a mistake, taking that shoot is barred by res judicata. That is a substantial question I have placed before your lordship. That is at page 7, my lord. Page 7, substantial question 3, my lord. Substantial question of law arises as to whether the learned lower appellate court committed illegality by deciding the point of res judicata against the appellant as the land and the party involved in essay number 4/1994.
You were reading point number?
Point number 3, my lord. Page 7.
So which part of the judgment the lower appellate court had dealt with the issue?
My lord. Just 1 minute, my lord. But it starts from page 54, my lord. Relevant portion I am giving it. So, your lordship, page 69. From the grounds of appeal and pleadings of the parties, following points for determination emerged in this appeal. Points for determination. Page 69. my lord.
Yes.
So points for determination in this appeal. Whether suit is hit by principle of res judicata. First point taken. my lord. Whether suit is bad for non-joinder of necessary parties. Now your lordship will please to see page 70, decision and reason thereof, whether suit is hit by principle of res judicata. After perusal of exhibit 8, it appears that the subject matter of TS number 172/83 included that covered by land tag number 170, Khotiar number 101. The subject matter of the suit from the schedule of the plan as well as from the exhibit 8, it appears to me that subject matter of TS number 172/83 as well as second appeal so and so, whereby Honorable Guwahati Court already affirmed the judgment passed in TA number so and so. Thus, it is apparent that the issue relating to the land covered by tag number 719 Khotian number 101 has already been decided by Exhibit 8 in view Section 11 of the CPC. I have arrived at the considered opinion that instant suit is not maintainable, being barred by doctrine of res judicata. I have perused the evidence available on record as well as pleadings of the parties, and upon perusal, I am of the considered opinion that observed by Lion Munshi appears to be justified because issues in both cases, PS number so and so appears to be same in both cases. Issue is regarding the alleged tenancy right of the plaintiff and defendants over the portion of land measuring so and so. The Honorable Guwahati High Court so and so. The plaintiff are not the tenant under the defendants in respect of the point measure so and so. Now, Your Lordship, accordingly, this point is decisively affirmative in favor of the respondent defendants.
So the Khatian number is same, 101,
Khotian number is same.
but that number is different. One is 419 and the other is.
That is one point. That is one point. And another point is it should be between the same parties. I was not party in the earlier shoot. My lord, the Section 11 of the CPC, it is said it should be between the same parties. There is a difference of drug number also. And another point is this, I was not the party. How res judicata will come? It should be, subject matter may be same, but I was not party before the court. So how res judicata will come without being myself being party? So Section 11 will not apply.
Whether Section 11 says about the parties or the subject matter.
Yes, my lord, Your Lordship. No court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially issued in a formal suit between the same parties. Between the same parties. I was not the party.
And
So-
subject matter is one of the condition.
One of the point, my lord, and Your Lordship, subject matter may be same. Issue in a formal suit between the same parties. Between the same parties. So I was not the party there. So I could not plead my case before the court below, my lord. So res judicata will not come. That is why Your Lordship, by order, directed me to produce the judgment. I have produced this judgment. Here I am not part. That is Exhibit 8. That point Your Lordship raised and said that you annexed the judgment. So from the reading of the judgment, I was not party. If it is not between the parties, my lord, res judicata will not come. That is my humble submission with you. And there is a difference in land also, my lord, that the DAG number, Khotian number is same, DAG number does not carry. That is why, my lord, it is squarely covered this Section 11.
So in which page you have formulated the substantial question of law?
My lord.
Page number?
My lord, page number 7. Substantial question number 3, my lord.
Question number 3.
Yes, my lord.
So
And-
according to you, this is the only question.
Now, another question, my lord, page, serial number 4 also. my lord. Substantial question of law arises as to what the point for non-joinder of necessary party, namely Jamal Sheikh, was illegally decided by the lower appellate court because against Jamal Sheikh, the appellants did not claim any relief. So, my lord, Jamal Sheikh and myself, both are tenant. There was a challenge in earlier suit between Jamal Sheikh and the Jodha. And now, my lord, court below decided that why Jamal Sheikh is not made party. I have no clash with Jamal Sheikh. I am with Jodha only. So Jamal Sheikh is not a necessary party. if we go through this CRPC, my lord, regarding necessary party.
CRPC or CPC?
CPC, sorry, my lord, CPC. So I have agitated 2 points, my lord. Non-joinder and this.
Okay, we'll go through the record.
My lord.
We'll pass the order.
My lord. Appeal may be admitted and there is an application, my lord, under that is IA civil number 3633, my lord. 3633.
This is for what purpose?
It is for injunction, my lord. My lord, here what happened, my lord, my suit was dismissed. Only thing is this, my lord, they may try
So
on the
first we
basis
have
of-
to admit the appeal.
Yes, my lord.
Only thereafter we'll consider this IA.
My lord.
We reserve the order. Heard Mr. MSA, learned counsel for the appellant. List the matter on order, argument concluded, order reserved.
Item 19. So, my lord, appeal is admitted.
No, we'll see. We will examine both the judgment.
My lord, oblige, your lord. Item 19. A date has been fixed, my lord.
No. Shortly, next week.
Next week, oblige, your lord.
Yes.
Lordship, in this, you filed this appeal in agreed by the judgment and decree passed by the Civil Judge Senior Division Golaghat in title appeal number 9 of 2022 on 24/1/2024, wherein the appeal was being allowed, thereby setting aside by the way of modification of the judgment and decree dated 28/7/2022, passed by the learned Munshi Thansi at Kolkata. So far in this matter, my lord, we, the appellant, my lord, at the first instance, we filed a suit under section 6 of the specific relief act. The trial court, my lord, the learned court, learned Munshi, my lord, was pleased to pass the judgment in our favor, my lord. Therefore, my lord, the respondents, my lord, they filed an appeal, first appeal, before the first appellate court, my lord. And the first appellate court, my lord, was pleased to allow the appeal, thereby setting aside by way of modification of the judgment passed by the learned trial court. So far, my lord, section 6(3) of the specific relief act, my lord, it clearly speaks that, my lord, that no appeal shall lie against an order or a decree passed under this section, my lord. And here we have raised the substantial question, my lord, which is at page number 4, my lord. That is number 2, my lord, wherein
Page number 4.
Who is page number 4?
Yes.
Page number 4, my lord, point number 2, my lord. Of the memo of appeal, my lord. Of the memo. of
Yes.
appeal. Point number 2, my lord.
Mm.
Whether the defendant counter claimant, my lord, contesting a suit preferred under section 6 of the specific relief act can maintain a first appeal under order 41 rule 1 with section 96 of the code of civil procedure, challenging the judgment and decree that dismissed the counterclaim on merit after concluding trial, ignoring the statutory bar to appeal as embodied in section 6(3) of the specific relief act. And my lord, one more thing, my lord, which is coming to concern, my lord, is regarding, my lord, the bar imposed in terms of section 96(4) of the CPC, my lord, wherein under section 96(4), my lord, no appeal shall lie except on the question of law from a decree in a suit of the nature cognizable by courts of small cause when the amounts or value of the subject matter of the original suit does not exceed rupees 10,000, my lord. Whereas the suit was valued at rupees 7,000, my lord, and the entire appeal was being embodied on factual grounds, my lord. Point 3 of the substantial questions, my lord.
So whether the decree passed by the learned trial court was a consent decree? Whether the decree was passed with the consent of the parties?
No, my decree was after concluding, after recording of evidence, my lord, after proper adjudication, the decree was being passed. And it was passed in our favor, my lord. Thereafter, they filed an appeal, whereas there is a bar in terms of preferring an appeal, whether they would have come by way of revision, my lord. And that very part was not being discussed in the appeal which they have preferred. Whether why it was being entertained by the first appellate court.
No, you have referred to section 96 of the Code of Civil Procedure.
96(4) as well as section 6(3) of the specific relief act, ma'am.
What was the value of the subject matter
Value of the
of
subject.
the original suit?
Original suit was, my lord, rupees 7,000.
Rupees
7,000.
7,000.
Yes, ma'am. Rupees 7,000. My lord, if I would take,
Where it is mentioned?
my lord, in the plaint, my lord. Page number 7, my lord, is the copy of plaint entitled suit number 7.
Page number 7.
7, man. Page number 7.
5,000.
5,000. And including all the miscellaneous fee being paid.
So section 6 of the specific relief act.
Yes, my lord. Section 6, subsection 3, my lord. Clearly says, my lord, that no appeal shall lie from an order or decree passed under this section, my lord.
Whether the suit was instituted under section 6 of the specific relief act.
Yes, my lord.
Where it is mentioned?
My lord, at page 7 itself, my lord, the claim part. Suit for recovery of possession under section 6 of the specific relief act.
Page number?
7, my lord. The copy of the plaint.
Hmm.
Wherein the suit for recovery of the possession under section 6 of the specific relief act. And the same is also reflected over the decree also. If, my lord, for the moment it comes to the decree, my lord,
Hmm.
passed by the learned trial.
Page number?
Decree is, my lord, at page number 50. 50, my lord. Judgment and decree passed in TS 7 of 2012, my lord.
Page number
50, my lord. And starts from 52, my lord. Judgment. This is a suit for recovery of possession under section 6 of the Specific Relief Act 1963 of the suit law.
and this point number 2 is the substantial question of law.
Yes, 2 and 3, my lord.
Heard, Mr.
P does, my lord.
Learned counsel for the appellant. This appeal. Under section 100, read with order 42 of the Code of Civil Procedure is directed against the judgment and decree dated 24/1/2024, passed in title appeal number 09 of 2022, passed by the learned civil judge, senior division, Golaghat. It is to be noted here that by the impugn judgment and decree dated so and so, the learned civil judge, senior division, Golaghat has set aside the decree, judgment and decree by way of modification. Judgment and decree dated 28/7/22, passed by the learned Munsif within bracket M Dhansiri Horupathar in title suit number 7 of 2012. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugn judgment and decree dated 24/1/2024, passed by the learned civil judge, senior division, Golaghat in title appeal number 09 of 2022, and also peruse the judgment and decree dated 28/7/2022, passed by the learned Munsif number 1 Dhansiri Horupathar in title suit number 7 of 2012. Having heard the submission of learned counsel for the appellant, this second appeal is admitted on the following question of substantial question of law. Number 1, whether the defendant struck counterclaimant contesting a suit referred under section 6 of the Specific Relief Act 1963 as amended can maintain a fast appeal under order 41 rule 1 read with section 96 of the Code of Civil Procedure, challenging the judgment and decree that dismissed the counterclaim on merit after conclusion of the trial, ignoring the statutory bar to appeal as embodied in section 6 3 of the Specific Relief Act. Number 2, whether the counterclaimant has a statutory right to file a regular appeal under order 41 rule 1 read with section 96 of the Code of Civil Procedure with a set of factual grounds in view of statutory bar imposed by section 96 within bracket 4 of CPC. While admitting the counterclaim valued at rupees 7,000 and the suit struck counterclaim is cognizable by the court of small causes, question mark. Let notice be issued, returnable in forex, step be taken by registered post and also by all with AD and also by usual process within a week from today. Recess will call for the record. Please the matter after 4 weeks.
There is also one interlocutory application, my lord. Accompanying with the said appeal is regarding the stay of operation of the impugned judgment, my lord.
Heard Mr. So learned counsel for the applicant and also heard. No, not necessary. Last line. This interlocutory application under order 41, rule 5 read with section 151 of the Code of Civil Procedure is preferred by the applicant for staying operation of the impugned judgment and decree dated 24/1/2024. Passed in title appeal number 9 of 2022. Passed by the learned civil judge senior division at Gulagat. The learned counsel for the applicant submits that the connected second appeal has already been admitted by this court by framing substantial question of law, and the record has also been called for. And is there any urgency?
There is no such urgency, my lord. There is no such urgency.
Then let the record come. We will
Yes,
consider your
let the
appeal.
record.
As the record has already been called for, the pair made in this application will be considered after perusing the same. Please the matter after 4 weeks.
Madam 20. Obliged.
Your lordship. The suit was for specific performance of contract, your lordship. Lordship, the plaint starts from page number 6. Your lordship peruses page 8, your lordship, for the time being. The contention of the plaintiff is that there was an oral agreement, your lordship. Initially, there was an oral agreement. Thereafter, there was a
Page number,
page number 8, your lordship.
point number.
Point number 8 and 9, I'm reading.
Hmm.
That the deceased Raju Narjari, husband of defendant number 1, entered into a written agreement for sale on 7/8/2018 as aforesaid land and received full consideration of rupees 4 lakhs from the plaintiff for his medical treatment ailing from liver disease, as stated before the plaintiff. The payment was made in full on 7/8/2018 in cash in presence of witnesses. That the deceased Raju Narjari, the landowner, received full consideration of the amount of 4 lakhs at the time of the written agreement on so and so. The payment was also was made fully to Raju Narjari since deceased in cash in presence of the witnesses and handed over the possession of the suit land to the plaintiff with metes and bounds. This was the stand of the plaintiff, your lordship. Thereafter, the suit was based on this. The suit was filed against the wife of this person, Raju Narjari, because he was dead by that time. In the written statement, which starts from page 12, in page 13. Page 14 to be precise. In para 10, the wife has replied against this contention, your lordship. What is stated? The statements of para 7, 8, and 9 of the plaintiffs are denied. The statements are false and concocted. The husband of the defendant number was not in a position to move and he was bedridden at the relevant period of time. The sisters of late Raju Boro and some villagers of so-and-so village brought some false allegations against the defendant number 1, that is the wife, with some ulterior motive and held a meeting, assaulted and beaten her in the meeting and turned her out of her home and warned her not to come back to her matrimonial house. So at that time, she was not at the matrimonial house. For this event, the defendant number 1 through her brother lodge an FIR so and so. The case is pending in sessions court so and fixed on so and so for CC. The defendant has not yet received a copy of the alleged document of agreement, so the defendant reserves the right to file additional written statement. So she pleads that she is not aware of any such agreement because at that point of time she was not at the house. She was driven out by the sisters of the deceased husband. This was the factual position, Your Lordship. Now, coming to the part of the judgment, Your Lordship, page 54. These were the pleadings, Your Lordship. Now, page 54. Para 35.
Para?
Para 35.6, Your Lordship. DW1 is the wife. The defendant. Para 35.5, the DW did not exhibit any documents, however, submitted evidence in chief. DW1 in her chief denied the case of the appellant and also claimed that Exhibit 1 is a forged and manufactured fabricated document. DW1 during her cross-examination admits that she does not know the appellants or plaintiffs. She also admits that the appellant has filed the suit for 1 bigha land. She admits and clarifies she does not know anything about the agreement by her husband. She states and admits that she does not know anything about the agreement by her husband. And in page 55, line number 6th line, Your Lordship, she also clarifies that on 7/8/2018, she was not present at her matrimonial house. It is something she has stated. Thereafter, the agreement, Your Lordship, was in Bodo language. It is translated by the court in para 36. Para 36, page 55 only.
Yes.
This is the agreement that is translated in page 56. The names and of the witnesses were also given. And I have examined this Ranjit Basumatari and Derhasat Basumatari as PWs 2 and 3, who were the witnesses to the agreement. And based upon this, Your Lordship,
So,
this court,
whom you have examined? Raju Narzari.
Ranjit Basumatari, Raju Narsari was the deceased executor, Your Lordship. Page 56, the witnesses in the agreement. Ranjit Basumatari was PW2 and Derhasat Basumatari was PW3.
Yes.
Now, based upon this, Your Lordship, in page 61, before that, the court came to a finding that since the plaintiff has failed to prove as to why there was no readiness and willingness, there was no application for NOC, that is why the suit was not, it was not believed, the plaintiff's version was not believed. Thereafter, in para 48, if I may read, page 61, moreover, the learned counsel for the appellant plaintiff has during the arguments highlighted that at least the earnest money ought to have been directed to be returned by the trial court. On this point, it is pertinent to mention here that though the appellant should not prove the suit for specific performance, and that of, but through his own testimony, PW1, and that of the other two witnesses, PW2 and PW3, he could prove the amount of rupees 4 lakhs has been paid to him, to Raju Narzari on 7/8/2018. So I'll take a pause here, Your Lordship. The court found that there was payment of the money. And previously, the fact of transfer of the land, possession of the land was also pleaded, which was not denied by the defendant, Your Lordship. So when there is a transfer of money, it was proved by the, it was found to be proved, and there was the possession was also handed over. That was not denied by the defendant. Under such circumstances, I have framed a substantial question of law at page 4. Point number 4. Substantial question number 4. Whether the learned courts below were justified in holding that there was no oral and written agreement for sale, even when the payment for consideration of money was proved and the possession of the suit land was also handed over to the plaintiff. This is the main substantial question of law that I am proposing here, Your Lordship, along with question number 1, if Your Lordship pleases. Whether the learned courts below were justified in disbelieving the exhibit number 1, agreement for sale, on the ground that the same was
No,
not a
it is a question of law or question of fact. Four, serial
Lordship,
number 4.
Lordship, the court has already recorded its finding regarding the transfer of money, Your Lordship.
Hmm.
And regarding this transfer of possession of the suit land, the court has not discussed anything. There was a pleading to that effect that the entire plot was handed over.
Hmm.
There was no denial by the defendant side that the plot of land was handed over, the possession was handed over to the plaintiff. Now, under such circumstances, the holding that there was no agreement for sale, whether that was justified because payment of money was proved. If there was no agreement, so why the payment of money was proved? Why there was a payment of money, and what about the handing over the possession? That was not discussed by the court.
Can this point number 4 be a substantial question of law?
If,
Hmm? Should be a question of fact, of course.
Joshua, if it is rephrased in a manner,
Hmm?
if I may be permitted to rephrase this question number 4.
Hmm. When?
Tomorrow or day after tomorrow, maybe.
Day after tomorrow.
If next week also it's possible, there is no such urgency.
Kobe?
Worship next week.
On the appeal being made by Mr. B.J. Mukherjee, learned counsel for the appellant, recessal is the matter on Monday,
But not Monday, too many cases. On 14th.
14.
Item 21.
Right, please. The second appeal, Lordship, against the decree passed by the first appellate court. The plaintiff suit was decreed by the learned trial court thereafter. In appeal, Lordship, the first appellate court has dismissed, set aside the decree. Therefore, the second appeal, Lordship, I am providing the substantial questions of law for convenience of the Lordship.
So what are the main points here
Lordship,
out of this 8 questions?
Lordship. No. Very facts, very briefly in one line I said, Lordship, that the father died in 1992. The 6 sons have shared the land amicably among themselves. And thereafter they have constructed their own houses. Someone has sold this property also. There's no dispute, nothing of that sort. Now the plaintiff, this land is located between 2 roads, PW roads. One is Borua Ali, one is Nahor Ali. Both are PW roads. My portion is there in that western side of the road. And this is connected with Nahor Ali. Defendant number 1, his land was located behind me. That was connected with Borua Ali. Now all have settled their own part, mutually partitioned their lands. And the defendant number 1 has sold out part of his land also to somebody else. No objection, nothing. Now, since my land is located at Nahor Ali, I made a small pathway from my land to go to Nahor Ali and put a gate there. All of a sudden, defendant number 1, who has got his own land and sold a part of it with no objections, he claimed that my gate should be kept open for his ingress and egress to the Nahor Ali side, which is my, he has got a land, he has got a way to reach the other side of the Peribli road. Now, because of all these things, partition had taken place mutually. Now, compelling situation, I filed a suit for declaration of my right to an interest over the land which I am possessing. And he himself in the WS is very clearly said that I have no claim on the land taken by the plaintiff. I am only claiming a right to enjoy the pathway to go to that. Now, the suit was decreed, Lordship. He found that he has, in WS, he has admitted that he has got no claim over the suit land over which I am claiming right to interest. He simply case that only with the pathway. Because it was decreed. But in the appellate stage, Lordship, that the decree was set aside. Now the question is that, Lordship, whether suit filed with a plaintiff for declaration of his right that to an interest over a suit land by virtue of inheritance, heirship, and possession can be dismissed merely because defendant number 1 claims the right to use a small strip of the suit land as a common part among all. Now, Lordship, he has not, my first prayer was that to decree that suit, declaring my right, title, and interest, which that portion of the prayer has been admitted by the defendant number 1. Second, my prayer was that injunction. Therefore, that is a different question. So, when it's admitted, because he has sold a part of his land, no objection. Other brothers also, they have constructed the houses. No one is objecting because it's mutual partition. Merely because he is claiming my pathway to be used as a common pathway between him and me, which I have registered. He started getting all the troubles that compelled me to file a suit. Now, when it's admitted by the defendant number 1, my right, title, and position, therefore, it cannot be, Lordship, it need not be proof regging. Partition need not be proof regging because all are accepting the partitions. Therefore, Lordship, submission is a substantial question of law. These questions, it may be, yes, we admitted for hearing. But kindly see round 6, next page, Lordship. What a suit filed for declaration of right title in interest of the plaintiff over the suit land in accordance with the family partition can be rejected by the first appellate court, while the defendant number one clearly states in his WS that he does not have any claim over the plaintiff's property, except his right to use the approach path, along with the plaintiff and others. He doesn't claim anything, Lordship. That's the particular WS also, the para I can read it for Lordship. Please. Lordship, page 23, the relevant para of the WS. Para 15, Lordship.
Yes.
Lordship, I just read. The statements made in para 12 of the plaint are denied. It is denied that the defendant number one has infringed the plaintiff's legal right of using the property described in the schedule of the plaint. It's not interfering in my right over the plaintiff. This defendant does not have any claim over the plaintiff's property. The suit claim which I am claiming, he admits that he's got no claim. He has claimed his right over the approach part, over which plaintiff wants to show his exclusive right. He doesn't deny my ownership of the property. Then it's partially admitted, Lordship, that part of the prayer that I said I was seeking a decree, Lordship, declaring my right to interest over the land which I'm possessing. That was decreed by the learned trial court, and that should not have been disturbed by the learned appellate court. That has been wrongly set aside, Lordship. Please say. Very question of law with that.
That's all right, but there cannot be so many substantial
I
questions.
thought Lordship decides that you may strike up. But is that may be there's a
Can it be reformulated?
Lordship.
Because all these have overlapping each other.
No, this 6 is very important, Lordship. Then Lordship, kindly to para ground number 2. Ground number 2 and Lordship, yes, ground number 2.
2.
Lordship.
Yes.
But a mutual family partition the ancestral land entered into between all brothers, including defendant number 1 and the plaintiff, to share the said land in a specified manner, and all having possessing their respective shares of the land as per the said family partition, can be disregarded by the first appellate court merely because the said mutual partition has not yet been entered in the revenue records. These two grounds, Lordship, substantial. This maybe
this one.
This ground number 2 and ground number 6 I have just read.
So these two are the substantial question of law according to you.
Lordship.
So we'll resume at 2. In the meantime, you again go through it.
Lordship.
Thereafter, we'll dictate the order.
Lordship.
You see if any modification can be made in this. At 2, we'll resume.
Lordship. I mean, interim prayer also, interim application, I find that Lordship will take up thereafter.
Yeah.
Oblige.
Pardon me, sir.
R.P. Kapati.
Learned counsel for the appellant. Senior. Learned senior counsel assisted by.
Yes,
Learned counsel for the appellant.
as Sutradhar is a sitting legal.
This second appeal is directed against the judgment and decree passed by learned civil judge, Senior Division Saraideo Sunari, in title appeal number 06 of 2022. Passed on 21st of February 2024.
I do.
It is to be noted here that by the impugned judgment and decree dated so and so, the learned civil judge senior division, Saraideo Sunari. Where is the judgment of civil judge? Operative part is 42? No, 42 is the Munsif.
Lordship, I just explained. The yes, Lordship, that where yes, yes.
No, first appellate court, judgment of
is
first
page
appellate
50,
court.
Lordship.
Judgment of first appellate court.
Or that page 50, Lordship.
50.
Lordship, it's page 50. Yeah. The order, Lordship, that what is page 80, 80.
Has set aside judgment and decree passed by the learned trial court. In title suit number 06 of 2020. And the corresponding decree. Where is the memo of appeal and the grounds mentioned therein? And also where is the impugned judgment and order, judgment and decree dated 21st February 2024, passed by learned civil judge senior division Saraideo in title appeal number 06 of 2022, and the judgment and decree passed by the learned Munsif Saraideo Sunari in title suit number 06 of 2020, dated 30th day of September 2022. Having heard the submission of learned senior counsel for the appellant, and also considering the facts and circumstances on the record, this second appeal is admitted on the following substantial question of law. Number 1, 4 and 6.
4 and 6, Lordship.
Whether the existence of a family partition family mutual partition can be ignored, stroke denied by the learned first appellate court, while none of the defendants stroke brothers objected to the said partition, and all have taken possession of their respective shares of the land according to the terms of the said partition. Number 2, whether a suit filed for declaration of right, title, and interest of the plaintiff over the suit land in accordance to a family partition can be rejected by the first appellate court, while the defendant number 1 clearly states in his written statement that he does not have any claim over the plaintiff's property except his right to use the approach path along with the plaintiff and others. Issue notice to the respondents, returnable in 4 weeks. Step be taken by registered post and also by result process within a week from today. Rest is call for the record from the learned trial court and also first appellate court. List the matter after 4 weeks.
But interim application has been filed, praying for stay of the operation of the impugned judgment.
Say hard.
I never do.
This application, interlocutory application under order 41 rule 5 of the Code of Civil Procedure is referred by the appellant Sri Gopal Borkotuke for staying the order of execution. No, for staying the execution of the judgment and decree dated 21/2/2024 passed by the learned civil judge, Senior Division Saraidev, entitled appeal number 06 of 2022 till disposal of this appeal. The learned senior counsel for the petitioner applicant submits that connected appeal has already been admitted by this court and the record has also been called for, and submits that till disposal of the appeal, the operation of the impugned judgment and decree dated 21/2/2024 may be stayed. Para, having considered the submission of learned senior counsel and also considering the facts and circumstances on the record, the impugned judgment and decree dated so and so stands listed till returnable date.
Deeply obliged.
Pending item number 13, bail hearing. Item number 13, timing matter.
On last three occasions also they have taken time notes. On last three occasions they are not doing the case also.
Absent.
No, they're not absent. They are taking time notes.
Let us see. Wait for a while.
Pending item 14.
Hello, my senior is at court number 17 after some time.
Pending item 16.
I think he has come.
16.
Next is your lordship. This is second bail application of this. Your lordship will find earlier order page 17. Earlier bail application was rejected considering the statement and the birth certificate of the girl. Now my second ground for second application is that lordship, that the certificate was subsequently obtained by the father, and I have enclosed the HSLC examination certificate that your lordship will find page 23. That shows that the girl was major at the time of alleged occurrence. And that is also seized by investigating officer lordship. That certificate, that seizure list I have also enclosed. Page 22 and 23. And subsequent to that lordship, they also got married lordship as per special marriage act being major lordship. Page 25 marriage certificate is also there.
Where is the certificate?
Page 23. Certificate issued by Board of Secondary Education Assam. As per section 94 of Juvenile Justice Act, that certificate will prevail also over.
When the occurrence took place?
Occurrence took place on lordship 6/9/2023.
What would be the actual age of the victim then?
18 years.
18 years to, if it is 2005, say, we think Lordship, then it will be 18 years.
Bail application with the direction to complete the trial within a period of 3 months, your lordship. That was the judgment passed by your, this, your lordship.
Where?
Thus, this judgment was passed on 12/2/24, your lordship.
12,
12/2/24, your lordship.
page number?
This order was not annexed, your lordship. I am
Not
having the-
annexed. But the very recent judgment, Bar Association Allahabad High Court versus State of UP. Their Supreme Court says that no timeline can be fixed for completion of trial by the trial court.
But your lordship, there was a direction by this honorable court. That direction
Maybe.
was-
Yes, Mr. Locker, why the witnesses could not be examined?
Your lordship, this is
Lordship, it was the LCR received before 2 months, Lordship, but Lordship, till then it was not examined. Summons were sent, but they have not come. But what is the present whether now?
I am having the
Yeah,
certificate copies of the, your lordship. I will
examine recently.
Okay, we'll see.
This is the order, lordship, your lordship, the copies of the order.
Long pending, that may not be a ground, Lordship. In the long
It is long
pending, that may not be a ground, Lordship, because in the case of Kalyan Kumar Sarkar, Lordship, it is opine, Lordship, that long incarceration that will not be a ground, Lordship.
Okay, the present petitioner is behind the bars since last 460 days, your lordship, without any progress in the case, your lordship, and that is the clear violation of Article 21, your lordship, that is decided in many cases.
What is the quantity of contraband substances recovered from his
Five.
possession?
567 grams.
Heroin. Heard, Mr.
IH plus P.
Learned Counsel for the accused and also heard Mr. P.S. Lofer, learned additional PP for the step postponed. Argument concluded, order reserved.
Item number 22 matters for orders.
Why not even last order 26 4? Here is the observation, there is a record was received, but that was not a complete record. Certain documents were for state. So accordingly, some communication was made. So as per the last office note, that is 31st/7, it is flag 9, the letter communication. Flag 9. So that is their letter in response to the letter of the registry. That is record they have verified that nothing has been
You were referring to office note dated
31st/7. Last order was 24. 26.
So, this flag X,
Flags 9 my lord, N my lord, N. Capital N, flag N. Last communication.
okay. It's flag N.
N.
Each of the classes. So as per this report, the record was already sent.
They are saying, well, but the lordship's order that is on 26/4. That was when it is reflected certain records were not in original manner. So that is why that communication was from the SB to the concerned WPC manner, WC commissioner. And in response to that letter, they have taken the things. These things, then minority lordship may fix for the hearing. This is nothing remains something.
We can fix, but can we decide the issue without a record?
This is the problem.
Hmm.
You say that this is it was sent through courier. So
Whether your purpose will be served if we
my
fix the
purpose
case
is
for
that
hearing.
the annex of 5 is concerned, it is the crux of the main issue because well, the certificate that was issued by a doctor other than the doctor who was examined as a witness. So this is the case. And moreover, the certificate that was issued long back and on the basis of certain guesswork. It is not based on any, he simply on the basis of his deformity, income, loss of income was calculated. But this is not the fact of the as per the guidelines of the Supreme Court also. So it is not that it is permanently disabled, everything is recoverable. And the issue was, certificate was issued by the orthopedic doctor and the witness was examined as a dermatologist. So this is the thing.
Doctor is examined.
Doctor is examined, but he is a dermatologist, he is not a orthopedic doctor. So whether that can be accepted or not.
Heard Mr. P. Mondo, learned counsel for the appellant, and Madam
I say.
I. Hussain, learned counsel for the respondent. How many respondents are here?
There were two respondents, but they probably appearing for the only one, my lord. The other proprietary did not turn up, my lord.
Office note dated 31/7/2024 indicates that a report, no, a letter from the no, a self-explanatory letter has been received from the Assistant Labor Commissioner, Commissioner Employees Compensation Nagaon has been received and the same is placed on record at flag N. Perusal of the flag N indicates that the original record of NWC 283 of 2001 was sent by Indian Courier dated 15/2/2016. Keeping some photostat copies in the dummy file. And on careful verification of the said dummy file, no original papers like the copy of examination in chief and cross-examination of the witness number 1 and 2 and original exhibits in connection with the case number NWC 283/2001 is found available in the file kept by the then Assistant Labor Commissioner Nagaon. Mr. Upadhyay, no, Mr. Mohanto, Learned Counsel for the appellant, submits that in view of the report of the Assistant Labor Commissioner Commissioner Employees Compensation Nagaon dated 10th of June 2024, the matter may be fixed for hearing. Accordingly, it is provided that Resti shall list the matter for hearing in usual course. Mr. Mohanta, so do we fix a date here?
Maybe any month of September.
September.
On 3rd September.
September, my lord, this is 17 or 24.
17. Okay.
Standing item 14.
There is a case, my lord, where I have prepared for 39 application for just like prisoner. Certain substantial issues are there. That needs a lot of kind consideration. Now, straightway I am coming to the FIR part. FIR contained in page 14, madam.
FIR is at page number
14, madam. One.
Yes.
Afterward, my lord, I preferred bail application. Page 16, that was rejected. Now, lordship, page 18 is the observation. Last part is operative part, page 18. Fourth line, madam. Page 18, fourth line. If the accused is released on bail, he is likely to tamper with the evidence. The accused may also abscond in order to evade the trial process. Considering those aspects as well as the length of detention of the accused in custody, the bail petition rejected. Now, second bail application, I again prefer the stage of framing charge. That is in page 19, my lord. Here, my lord, charge has been framed. And my lord, based on that, my lord, trial began. My lord, my bail application was rejected.
Were there any witnesses examined till
No,
now?
this is the present stage of witness examination stage. Now I am coming to the core issue. My lord, this is very important to look into, my lord. The recent Supreme Court judgment 18 July 2024 is very pertinent here. The whole issue about my lord, that protection of Article 21 speedy trial, wherein, my lord, the Honorable Supreme Court in paragraph 22 categorically observed that if prosecution failed to ensure about speedy trial, they cannot oppose the bail application even it is a serious or heinous crime, madam. I am addressing, my lord, some of the issues before your lordship. That is about the Article 21, my lord, speedy trial. Second thing is, my lord, about that what is the
Mr. Samaria, charge was framed on 3rd of May 2024.
But this is the issue. No, charge has been framed. Now there is a step for
Yes.
examination of witness.
Whether prosecution side is not required to be given appropriate or proper opportunity to examine the witnesses.
Absolutely, I do not have any objection. They have to examine, my lord. They
Then-
their rights, my lord. Question is that, my lord, suppose there are 2 or 3 facilities which require lordship kind consideration. In the light of the observation which has been made by the Honorable Supreme Court on 18 July 2024, my lord, judgment. That's why I'd like to draw the attention of this Honorable Court. Straightway I am coming to, my lord, paragraph 22, my lord. paragraph 22, page 12, my lord. This judgment, my lord, Sheikh Javed Iqbal. Here, my lord, the whole issue has been dealt with. Page 12, paragraph 22.
Hmm.
May I report? May I read, madam?
Hmm.
Paragraph 22. Page 12.
Yes.
It is tried law that an accused is entitled to speedy trial. This court in a catena of judgment has held that an accused or an under trial has a fundamental right to speedy trial which is traceable to Article 20 of the Constitution of India. If the alleged offence is a serious one, it is all the more necessary for the prosecution to ensure that the trial is concluded expeditiously. When a trial gets prolonged, it is not open to the prosecution to oppose bail of the accused under trial on the ground that the charges are very serious. Bail cannot be denied only on the ground that the charges are very serious, though there is no insight for trial to conclude. There is a clear-cut direction that has been given here. Now, I am coming to my lord. Next paragraph, page 13. That is also the part of this judgment, 23.1. Here, Lordship, kindly see, after referring to the various other decisions, this court further observe as follows. If the state or any prosecution agency, including the court, concerned has no wherewithal to provide or protect the fundamental right of an accused to have a speedy trial as ensuing under Article 20 of the Constitution, then the state or any other prosecution agency should not oppose the plea for bail on the ground that the crime committed is serious. Article 20 of the Constitution applies irrespective of the nature of the crime. Now, Lordship, this is one of the examples that has been taken care of. Here, my lord, next page 14, paragraph 21, part of the judgment. Next page. We are convinced that the manner in which the prosecuting agency as well as the court have proceeded, the right of accused to have a speedy trial could be said to have been infringed, thereby violating Article 21 of the Constitution of India. Now, Lordship, one of the cases that has been taken care of, page 15, paragraph 26. Page 15, paragraph 26. This is one of the case, Angela Harris Sontaki. In this case is a case where the accused appellant was charged under various provisions of the UAP Act as well as under the IPC. He sought for bail. The court observed that undoubtedly the charges are serious, but the seriousness of the charges will have to be balanced with certain other factors like the period of custody suffered and likely period within which the trial can be expected to be completed. In that case, it was found that the appellant accused was in custody since April 2011 for over 4 years. The trial was yet to commence. A large number of witnesses were proposed to be examined. It was in that context that the appellant accused was directed to be released on bail. Now, next downside matter, paragraph 27.1. This court noted that the appellant in K. Najib Supra was in jail for more than 5 years. Charges were framed only on 27/11/2020 and there were 276 witnesses still left to be examined. The court emphasized that liberty granted by Part 3 of the Constitution would cover within its prospective ambit not only due procedural and fairness but also access to justice and speedy trial. No under trial can be detained indefinitely pending trial. Once it is obvious that a timely trial would not be possible and the accused has suffered incarceration for a significant period of time, the court would ordinarily be obligated to enlarge them on bail. Referring to the decision of this court in Nia Jahur Ahmed Shah Wadali, this court opined that the High Court in that case has virtually conducted a mini trial and determined admissibility of certain evidence which clearly exceeded the limit scope of bail proceeding. Not only was it beyond the statutory mandate of prima facie assessment under Section 43D5 of the UAP Act, it was premature and possibly would have prejudiced the trial as well. It was then circumstances that this court in Jahur Ahmed Shah Watali had to intervene, leading to the cancellation of bail granted. Paragraph 28. We are respectful agreement with the reasoning given in K. Najib case regarding the decision of Jahur Ahmed Shah The decision in Jahar Ahmed Shah Watali Supra has to be read and understood in the context in which it was rendered, and not a precedent to deny bail to an accused under trial suffering long incarceration with no end in sight of the criminal trial. Paragraph 29. Going back to A.K. Najib, this court thereafter proceeded to hold that Section 43D of the UAP Act does not alter the ability of the Constitutional Court to grant bail on ground of violation of parts of the Constitution. Long incarcerations with the unlikelihood of trial being completed in the near future is a good ground for granting bail. This is clearly indicated. Now, finally, my lord, this honorable Supreme Court come to the conclusion that though this is a serious offense, but taking note of the indefinite situation, the bail was granted. And one part I would like to read, my lord, page 25, paragraph 32. Paragraph 32. This court has time and again emphasized that right to life and personal liberty insisting under Article 21 of the Constitution of India is overreaching and sacrosanct. A constitutional court cannot be restrained from granting bail to an accused on account of restrictive statutory provision in a penal statute if it find that the right of accused under trial under Article 21 of the Constitution of India has infringed. In that event, such statutory restrictions would not come into the way. Even in a case of interpretation of the penal statute, howsoever stringent it may be, a constitutional court has to lean in favor of the constitutional regime and rule of law of which liberty is an instinct part. In the given facts of the particular case, a constitutional court may decline to grant bail, but it would be very wrong to say that under the particular statute, bail cannot be granted. It would run counter to the very grain of our constitutional jurisprudence. In any view of the matter, K.A. Nazib being rendered by these three judges in binding on bench of two judges like us, thus having regard to the discussion made above, we are of the considered view that the continued incarcerations of the appellant cannot be justified. We are therefore inclined to grant bail to the appellant. But this is also a serious case where, my lord, the basic point, my lord, about speedy trial, why and my lord, reasoning behind that, my lord.
No, the question is whether your right to speedy trial is violated here in this case
Yes,
or
my
not.
lord. I am coming to that justification. Lordship, can it take for a moment? There are 50 witnesses to be examined. This is the part list of witnesses clearly indicates.
15.
50 witnesses.
Yes.
Now 50 witnesses, my lord, the charge was framed on 3/5/2024. Till that, my lord, 2 dates has gone away. Out of which, my lord, prosecution, my lord, that public prosecutor even not issued notice to the, my lord, concerned witnesses, my lord. Now taking in that manner in a year, my lord, maximum, my lord, 5 or 6 witnesses possible to be examined. Taking that way, my lord. Then it takes 5 years, my lord, minimum. Now, this is one of the reason where, my lord, because I have cited one citation where it says that if there is indefinite period, which clearly reflects from their own position of the case that 50 witnesses need sufficient time, my lord. Apart from, my lord, thereafter, my lord, other part of the proceedings are there, my lord. In between, my lord, absence or, my lord, that so many reasons are otherwise there. Question is that, my lord, this judgment is very much pertinent on one point. Paragraph 22 clearly indicates that the nature of crime doesn't mean. Question is that if a person otherwise deprived from getting apparently from speedy trial, my lord, then his right accrued therefore in the light of the Article 21. Therefore, my lord, the objection which otherwise they have to raise that it's a serious crime, is a 302 Arms Act involved there. That is not the issue. Issue is that if you fail to substantiate the position that in near future there is indefinite period run along therewith, out of which, my lord, it takes time, then a person is entitled. It's a matter of entitlementship of bail.
How can it be said that for indefinite period they will not be able to examine the
Yes,
witnesses
madam.
and
I'm coming
complete
to
the
that.
trial?
Yes, madam. Let us take, my lord, for a moment that once this charge has been framed, my lord, now they enter into the zone of examination of witnesses. Now, examination of witness, what nature of witnesses are there, my lord? Let us also think in that point. There is FSL witnesses are there. There are suppose I was there. Thereafter, suppose some outside witnesses are there. Their natures of multiple, my lord, characters are there. Out of which, my lord, this last 2 incidents clearly indicates that in a year, 5 or 6 witnesses or 10 witnesses even taking that way, my lord, maximum.
No, that is only presumption.
My presumption, but it has reason, my lord. It followed by, my lord, certain.
No, that cannot. Merely because for 2 months no witnesses have turned up. Can it be said that for remaining period of the year also no witnesses will be turned up?
The lordship is quite right. Suppose that his witness is started. Let us take in different hypothetical.
Forget about this hypothesis. You so that your right is violated.
Yes, my lord. But reason behind that, my lord,
Mm.
the position clearly reflects
Mm.
that in order to deal with the 50 witnesses, my lord, the practical position which is reflected in the court itself says that one person get dead after 2 months, my lord.
Mm.
Once he gets 2 months, the one absent is there, my lord. Otherwise, my lord, that the prosecution witnesses, my lord, sometimes may not be able to come. Sometimes prosecutor, my lord, he may not be in a position to that. Ultimately, question is that, my lord, if there is no any assurance that the position reflects that the 50 witnesses it should be examined within a, my lord, definite period, my lord, then this paragraph 22 ultimately clearly indicates from that point of view. My lord, this is one of the ground. I am coming to the second point, my lord. What is the definition of prima facie case? My lord, reason that while granting bail, my lord, thus Honorable Supreme Court clearly indicates 2 or 3, my lord, issues.
No, you cannot argue on that point because SARS has been framed against you. What does it mean? It means that there is prima facie case against you.
Exactly, my lord. The prima facie case against me, understood, my lord. Very
Mm.
good. This is the basic requirement for, my lord.
You
taking-
cannot argue on that point unless you challenge the framing of SARS order.
No, my lord, lordship just subject to your lordship clears. My lord, Honorable Supreme Court defined that how to test the issue of prima facie case.
No.
I'm referring, my lord, citation.
No.
My lord, so far the prima facie case is concerned, my lord.
No,
definitely-
the learned trial court has already framed SARS having
Just
found
to
prima
restore
facie case
time
against you.
order, my lord. Even my lord,
Unless that finding is a overall, you cannot.
my lord, mayor saying one word, prima facie case. my
And
does-
there is also finding of the trial court, yes. That if the accused is released on bail, he is likely to tamper with the evidence.
Exactly, my lord. That's why I'm questioning, my lord. That I'm coming to one citation of this Honorable Supreme Court where it says that in case of serious offense where bail ought to be rejected, then reasoning must be shown. But this is not a reasoned order, my lord.
Why?
Reason behind is that, my lord, how I can be absconded? I am the permanent resident. My father permanent resident of the Guwahati city, my lord. I am the businessman of Guwahati city, my lord. I am not a person belongs to, my lord, outside of India. I am not the person relates to outside state. There is no any examination, my lord. That, my lord, this one example I am giving, my lord, that how this test has to be done, my lord. Absconding issue. My lord, there is Satyendra Kumar until his case 2022. Lordship, just look for a moment. I have given the citation, my lord. This test, how to be examined, my lord, there is your own citation. My lord, this is Satyendra until his case, my lord. My lord, page 43. Now let us take lordship views that absconding part, my lord. Does it really survive, my lord? Page 43, my lord. The relevant part is paragraph 4, my lord. My lord, the last line, my lord, middle part. Page 43. My lord, middle part, if the court is satisfied, line start form. Lordship got it?
Page 42.
43. 43, my lord, second paragraph, middle part, if the court is satisfied after. If the court is satisfied after taking into account on the basis of the information placed before it that the accused has his roots in the community and is not likely to abscond, it can safely release the accused on his personal bond to determine whether the accused has his roots in the community, which would deter him from fleeing. The court should take into account the following factor concerning the accused: the length of his residence in the community, the employment status, history, and his financial condition, the family ties and relationship, his reputation, character, and monetary condition, his prior criminal records, including any record of prior release on recognition of bail. 6. The identity of the responsible members of the committee who would vouch for reliability. 7. The nature of the offence charge and the apparent probability of conviction and the likely sentence insofar as these factors are relevant to take responsibility. I'm just coming to this point, madam. Let us think that whether out of the 7, what condition I'm complied with. Lordship, it's a case of life triangle, my lord. It is not a case that he is a habitual offender, my lord. It is not a case, my lord, out of which, my lord, he has any otherwise, my lord, any allegation that out of which, my lord, he has committed any such kind of offense in, my lord, prior to that, my lord. It is also not a case, my lord, that this person doesn't belongs to Guwahati, my lord. His even forefather, my lord, are from this area, my lord. Apart from his
No, 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 Mr. Summary, I fail to understand how this paragraph will help you.
But reason that absconding part, Lordship put a very pertinent question that since the
No, no,
trial
there is a trial court has assigned the reason that he is likely to tamper with the evidence.
yeah, absolutely.
Tamper with the evidence and absconding are two different
Quite
facts,
right,
two different stages.
Lordship kindly take into both issues.
No, both cannot be read together.
Definitely, Lordship will re-examine that whatever that observation which has been made. Now we put before your Lordship for my lord kind consideration. Absconding part comes from where, my lord? Absconding parts come from a person doesn't hailing from the particular location. Well, yes, is a good reason. There is a good reason. That is not the case here, my lord. Now tampering of investigation, my lord. Kindly see, all person has already been arrested. Maximum those persons who are supposed part of this game, my lord, are already behind the bar. And my lord, what this, my lord, he's a 25 years old, my lord, students, my lord, after he started his business, my lord. What tampering he would do, my lord? The already all examination based, his party is only connected to that arms were recovered from him, my lord. Now, that is a matter of trial, my lord. That has to be in the light of 106 Evidence Act. The burden proof goes to them, my lord. Onus goes to them to prove that whether this arms carried out by me or not, my lord. Lordship, I am coming to this point, second point, my lord. 309 of the CRPC, my lord. 309 CRPC clearly says, my lord, that it is also interconnected with the issue of, my lord, speedy trial. I am coming back to that point, my lord. Now, Lordship, kindly look for a moment that 18 July 2024 judgment, why emphasize on paragraph 22? If we see that, yes, the prosecution is allowed to examine their witness, whatever time that will take, yes, then I don't have any case, my lord, at all. But if Lordship revise the situation for a moment, in the light, if Lordship look in the light of paragraph 22, then Lordship definitely see that what are the numbers of witnesses. And my lord, is there really a case that whether I will interfere there? Is it really?
No, only 15 witnesses have been cited in the search sheet, not 100 and 150 or 200 witnesses like that.
Then Lordship, if this is the answer, then nobody will get a bail.
No.
Nobody will get a bail, my lord, because this judgment, my lord, ultimately insist on one point.
Yes, all right. Yes, what is your submission?
Here in this case, Lordship, charge was framed on 5/7/2024, Lordship, and the next date was
5/7?
3/5/2024.
Yes.
And the next date was last gone on 10/7/24. And Lordship, on that day, there no witnesses was examined, Lordship. No coming. Only one date has gone as per record or LCR, Lordship. What another date got that I do not know. Only one date has gone. So on immediately after one day, gone, Lordship, pass away. Then Lordship, we cannot say that it will take long time, Lordship. And one judgment has been cited of the apex court, Lordship, that is of dated, Lordship, 18/7/24. But Lordship, I don't know how. But the Lordship, Allahabad High Court High Court Bar Association, Allahabad, Lordship, this is a 4 judges bench, Lordship. And in these judgments, Lordship, it has been clearly discussed that everything, Lordship, that it should not be there should not be time bound, Lordship. And even 309 has also been discussed, Lordship, because though there is a provision of 309, the day-to-day trial, Lordship, but due to the long pendency of the cases, Lordship, it could not be done. And it is if the trial court thinks fit, if the trial court decides that he will do the cases in day-to-day, then it is the trial court will follow that sections, Lordship. But Lordship, the High Court should not interfere in that case, Lordship, as per the judgment, because Lordship, there are so many people who cannot approach the High Court, Lordship. And in that way, Lordship, giving some special relief to some special people, Lordship, and that will amount to injustice to them, Lordship. It is in paragraph 31, Lordship, it is elaborately discussed, Lordship. And so, Lordship, even the Satyendra Kumar Ankhil case, Lordship, when there is beginning how the absconding part should be decided, Lordship. Here, one line I have heard, Lordship, that nature of the offense charged, Lordship. And there is also one line sentence on scope of coming out of conviction. That part we cannot say at this moment, Lordship, because without examining a single witnesses, Lordship. Today, only one date has gone, and for that reason, Lordship, that cannot be, because he has admitted in his 161 has come, Lordship, 161 statement, Lordship, he has admitted his guilty, Lordship. before starting the trial, before examination of the witnesses, we will go by the statement of the accused person after recorded under section 161. And in 161 statement, he has admitted his the entire thing, allegation level against him, Lordship. So Lordship, this is not a fit case to give him enlarge him on bail, Lordship, at this stage, Lordship. There is every possibilities of hampering of tempering, Lordship, evidences, Lordship, absconding also, Lordship, because there is a heinous crime and Lordship, this is very serious offense, 302 case, Lordship. So Lordship, at this stage, it should be rejected, Lordship.
Lordship, I would like to relate to side listen. Lordship, thereafter, my lord, whatever
Allahabad High Court.
I have to accept.
Allahabad High Court judgment is Lordship 3 judges bench, Lordship, and that is also Lordship 2023, Lordship. That citation I have the copy, Lordship, judgment, Lordship. It is also reported, Lordship. That citation I will give, Lordship. I have the hard copies.
Now, Lordship, as my learned friend has stated a thing which is otherwise, my lord, impermissible, that he wants to say that if suppose evidence is one of the part to take into account for consideration bail, my lord, then Supreme Court said no. The evidence should not be looked into, the maid should not be looked into. Then what look into, my lord? This is clearly indicated that prima facie case, my lord. Now, prima facie case flows from only two issues, my lord, as per the Supreme Court judgment, which I would like to let up says. First thing is FIR, and second thing is 173.
No, whether in that case, charge was framed or not.
Charge has already been framed, my lord. There is
No, in that case.
Yes, charge has already been framed, my lord. Charge has already been framed.
So then where is the question for finding out the prima facie case?
Parliament on 2 points, my lord. Can you see that I have 2 or 3 issues. First issue is about, my lord, that speedy trial, my lord. If lordship feel that 60 witness, 50 witness, take
No,
it.
speedy trial, you saw how your right is violated.
My lord, question is that, my lord, the position is very much clear that in order to deal with 60 numbers of witness, my lord, it's a clear-cut case. It takes time, my lord. Now, second, if I would like to defend myself, it's also right to defend, my lord. Then definitely, if I would be released, my lord, then definitely that right to defend, my lord, to be exercised in a proper manner, my lord. This is one of the ground, my lord. I can take, my lord.
That is not the ground for granting bail, Mr. Samaria.
No, it's a matter of right to defense, my lord. Lordship may not
No.
Lordship,
That right is available. You can exercise from jail also.
Can say absconding part? Lordship, absconding. I'm because my learned friend is saying 2 points. About
We'll see. We are not sitting in revision against the order passed by the learned additional district judge.
Quite right, my lord. Quite right, my lord. I'm not, my lord, saying that it's a case where my lordship will suppose take into consideration that re-examination fact. But question is that, my lord.
Take down heard Mr. Samaria, learned counsel for the accused, and also heard Mr. P.S. Locker, learned additional PP. Argument concluded, order is reserved.
Item 23.
Your Lordship, we have taken steps on 17/5/2024.
Pardon?
We have taken steps on 17/5/2024.
Upon respondent number?
One, your Lordship.
Then what happened? Is there any office note?
Office note,
But the office note indicates that you have not taken any step.
Yes, your Lordship, we will take the fresh steps again.
Miss, your good name?
He does.
Learned counsel appearing on behalf of Mr.
G. Bashir.
G. Bashir, learned counsel for the appellant, submits that she may be permitted to take a fresh step upon respondent number 1. Pair is accordingly allowed. Step be taken within 2 working days from today. List the matter after 2 weeks.
Nice.
24.
In this case, notice was issued on the substituted or a respondent, we have taken a step on 14/6/2000, 13/6/2023, we have taken a step. Now the notice has been issued. Now the office note said that neither the ID card or unserved notice has received back, and accordingly matter has been laid, madam. It's more than a year, my lord.
Can it be made through substituted mode?
Substituted, my lord, you can give me there, my lord, because already in my submission, my lord, they since the notice has been issued on the addresses given already by the court, my lord, registered post.
By registered post?
Yes, my lord, registered
Can
post.
you track it in the that departmental website? Track the consignment.
Lord, we don't have the numbers of the, my lord, that lordship wants to get the check in the postal tracking.
Yes.
But tracking we cannot do because the number is required. Registration number is not here, madam. The registration number that will be required.
You send it by registered post?
Huh?
You
No,
have sent
I have
it?
not. We have taken the steps. It has been sent by the registry, my lord. We have not sent it.
Registry.
Registry has sent it.
Well, then let the registry track it.
Let the registry take it and may not press the report, madam. That will be better, madam.
Heard Mr. K. Agarwal, learned senior counsel, assisted by Ms. Learned counsel for the petitioner, and Mr. Gupta,
For respondent number 8, man.
learned counsel for the respondent number 8. Office note dated 30/7/2024 indicates that neither ID card nor unserved notice issued to the respondent number 3.1 to 3.3 received back by the registry. In view of above, it is provided that registry shall track the consignment and put up an up-to-date office note on.
Either, my lord, they can place it before the Lojima court also, my lord. I leave to my lord, my lord.
We'll take up the matter. Registry will put up an up-to-date office note on next date. When? Short date? 16th August.
16th of August.
Yes.
Huh?
I don't know. 25?
16th of August to do. Can it be, my lord, that? It's all right.
25.
Any date you can.
I'll just inform
If
you.
there is any inconvenience.
I'll just inform you.
Okay. And inform Mr. Gupta also.
Yes, I'll inform Gupta.
Yeah, please, your lordship.
Yes.
Lordship, in this matter, we are yet to file our affidavit, your lordship, with regard to the paper publication. So lordship may grant us additional a week's time to file, your lordship. I'm on behalf of MS Roy, your lordship.
Your good name?
FN Jaman.
Ms. Jaman, learned counsel, appearing on behalf of Mrs. S. Roy, learned counsel for the appellant, submits that she will file an affidavit in respect of paper publication within a week. Within a week from today. And accordingly, price for listing the matter after there is accordingly allowed, rest is list the matter after 1 week.
Oblige, your lordship.
26.
May please, your lordship, that in this case, my lord, appellant's advocate withdrawn Okalatnama on 15/5/23 itself, my lord, last year, my lord, and thereafter registry, it is directed to registry to issue notice. Notice was issued, my lord, that notice was not served and returned back, and thereafter, my lord, again remainder notice is issued, but none is, my lord, come forward. My humble prayer, my lord, if 1 year has passed, my lord, your lordship may drop the case if necessary, my lord, they will come forward for restoration. Because, my lord, that in the both case, my lord, they have lose, my lord, they either should dismiss and appeal also may dismiss. And lordship may observe that if they any come, my lord, they have to that will be restored. I'll make no objection.
Heard, Mr.
See question.
Learned Counsel for the respondent. You're for the respondent.
Respondent, my lord, all respondent. From order is it 15/5/23, my lord, it start.
Mr. Goswami, referring to the order dated 15/5/2023, submits that the appellants have withdrawn their Ukalatnama from the case, though they have engaged Mr. G. Bachchan, Learned Counsel, to represent them. Thereafter, the registry had issued notice to the respondent number 1, no, to the appellants number 1, 2, 4, and 5. But till date, no Ukalatnama has been filed on behalf of the appellant side. Let us see another one date.
My lord, after 1 month or 2 months, one date may be fixed, my lord, so that
Having considered the submission of Mr. Goswami, Learned Counsel for the respondent, and also considering the facts and circumstances on the record, it is provided that rest shall list the matter
last week of September, one enough time will get.
September. And rest shall also put up an up-to-date office note in respect of service of notice upon appellant number 1, 2, 4, and 5. List accordingly.
27.
Lordship, I'm for respondent number 3 and 4. We no longer appear for the respondents. Our names may be struck off, Lordship.
Actually, my lord, nobody appeared, therefore court director has to make a paper publication. We made it, my lord. Lordship will find in miss case number IA 1262. 8212, Lord. One, 2, 6, 2, flag A. Flag A, flag A.
So when it was published in the paper?
On 20. Six 23.
Have you filed any Ukalatnama?
Lordship, probably in the second appeal, not for the restoration, etc.
Not for?
Not for the IAs that has been filed. We don't even have the file with us, Lordship.
Whether your name is reflected in the cause list?
Yes, my lord.
Yes, Your Lordship. Senior Counsel Mr. G.N. Sahiwala.
No, you are no longer the engaged counsel.
No, Lordship.
Oh, all the respondents.
For respondent number 3 and 4.
3 and 4.
Yes, Your Lordship.
To order to the say the 9. In which file your presence is recorded?
My lord, actually.
In the second appeal, Lordship.
My lord, My lord, actually, second appeal is dismissed for default. Earlier, these 5 set of petitions were filed. Actually, because of for not taking step by the earlier set of advocate, my lord, these 5 were.
This IA number 1262 is for
These
what
are all
purpose?
disposed of, my lord. These are all disposed of.
1262?
These are all disposed of and allowed. That is why, my lord, today, 2771, 2775 are listed today for consideration.
2771 and
No, 2771, 2772, 3, 4, and 5.
2, 3, 4, 5.
These 5 are listed earlier. This earlier miss cases are already allowed, my lord.
now what is your submission?
My lord, this 2771 is filed for condemnation of delay 138 days, my lord. For filing.
2771.
Yes, my lord.
Yes.
There are altogether 5 miss cases, my lord.
No, this miss case is for what purpose?
For readmission of the second appeal, my lord, which was dismissed on 28/6/2011. my lord.
So there was delay of 1138 days.
Yes, my lord. Lordship, we have explained from paragraph 5 onwards.
So this application was dismissed by the order dated 15/12/2017.
My lord.
All are dismissed.
Which paragraph?
No, in the order dated 15/12/2017.
15/12.
2017. In miss case number 2771.
Yes. Yes, my lord. That is for restoration of this miss case. We have 2771. Yes, my
Yes.
lord. All these 10 IA with that we have filed, that was allowed. That is why these are listed today for consideration. Total
These have
10 টা।
been dismissed.
No, no. It is dismissed for purpose of 10 টা file করতে। For restoration of this, my lord, 2771 to 2775, these were all dismissed. For restoration of this, my lord, we filed earlier 10 applications that were allowed. Those were allowed. That is why this application are restored to file and listed today for consideration.
This was used to by the order dated none in 1263.
IA 1263.
Restoration and discuss 2774.
Shall be restored to file.
2771. 2774 is restored.
Yes.
If you put 2771. You can see that the order dated 1260. 1260 2000 2774
No, as per order in IA Civil 1263/2018.
Yes, ma'am.
Only miss case number 2774 of 2014.
No, my lord, there is
is
orders
restored.
in every file. Common order, there is there is an order in every miss case, my lord. There are altogether 10 miss cases are there.
So by which miss case this 2771 is restored?
My lord, probably this is 1262.
Administration chocolate production release pending, release intelligent. 80 days later, 70 days delays. There has been such a
If the delay is conduct, delays then conduct.
Say to 1 to 16, 1 to 16,
Now, what is your pair in this petition?
My lord, this is already filed for continuation of delay of 1,138 days in filing the readmission order 41 rule 19 application, my lord. We have explained in paragraph 5 onwards. It is basically for not taking steps by the earlier set of advocates, my lord. This has happened. File was,
That's all right. Now, is it not necessary to issue notice to the respondents? Opposite
that is why,
party?
my lord, the paper publication was made. Earlier also from the beginning, nobody appeared. That is why court directed us. If lordship says, then we'll file separate another, then we'll have to make another paper publication. If lordship allows.
No, that would be proper perhaps.
Okay then.
After restoration of the file.
Miss cases. Okay.
Yes.
Lordship will give us some time.
Heard Mr. S. Chakraborty?
SK Chakraborty.
S. Chakraborty, learned counsel for the applicant. And madam, you are not in this petition.
No, Lordship.
Mr. Chakraborty, learned counsel for the applicant, submits that in view of restoration of this petition to file in view of order of this court in this case number 2. In IA civil number 1262 of 2018, he may be permitted to cause service of notice upon the respondent opposite parties by paper publication, by substituted mode by through paper publication. Pair is accordingly allowed. After publication of the notice in the paper, the counsel for the applicant shall submit an affidavit to that effect before this court. List the matter after 4 weeks.
4 weeks, my lord. 4 weeks, my lord, that a date has to be fixed for appearance of the respondents, my lord.
Lordship,
Otherwise,
struck off from the first list.
No, whether you have filed Ukalatnama in this petition.
In the earlier, in the second appeal we had filed, but we no longer have the file with us. That has
So
been.
now we are passing the order in the miss case, not in the second appeal. How can we pass the order? Because you have not filed your Ukalatnama in this miss case.
well, the lordship has passed in order in this case.
Miss case, yes, 2771.
Yes.
Okay, when?
23rd September.
23rd September.
No, my lord, it has to be after a month because.
After a month, yes.
Because they will take some time for issuing us a notice.
Yes, yes.
After a month, then my lord.
Suggest the date.
24th, 25th of September.
Okay.
For appearance of the opposite parties.
For appearance of the opposite parties.
My lord has not indicated the papers, or shall I?
Pardon?
Paper publication in the paper public not indicated the papers. Assam Tribune and Doinik
Two newspapers, two local newspapers, widely circulated.
Yes.
In which the
Nagaon, yes.
Nagaon.
Yes.
In which the respondents are residing.
Item 28.
Sometime may be given for fresh taken steps.
What?
Taken fresh steps.
Step. Pardon, Mr.
case is number.
Learned counsel for the applicant. Mr. Islam submits that he may be granted some more time to take step upon the respondent opposite party. Here is accordingly allowed. Rest shall list the matter on after 4 weeks.
2 weeks.
4 weeks.
29.
May it please your lordship. Your lordship, in this matter, service is not complete upon respondent number 1. Your lordship, kindly allow us to take steps upon respondent number 1 by way of Dusty.
Heard, Mr.
As Datta.
Learned counsel for the petitioner. Mr. Dotto submits that he may be permitted to take to effect service of notice upon respondent number 1 by Dusty, but here is accordingly allowed. Step be taken within 2 working days from today. Thereafter, the learned counsel shall furnish an affidavit to that effect before this court. Please the matter after 4 weeks or 2 weeks?
4 weeks. Your
4
lordship.
weeks.
Much less.
31.
Yes.
My lordship, kindly see, my lord, the last order dated 15/7/2024. There was an observation that since the respondent didn't appear continuously, the respondent number 1, 2, and 4, then endeavor were made to pass necessary order. Matter was dismissed for default, my lord, and petition is within the time. And at the same time, my lord, both the matter were taken up by the court on the same time, my lord, as a result of which I could not appear. And then, my lord, within the shortest possible time, ultimately, my lord, I made this application. Notice was directed to be issued, notice was issued, my lord. And court has taken the presumption in respect of 1, 2, 3, 4, and 5. 1, 2, 4, 5. And sufficient time was given for them to appear, they didn't appear. And it is a, my lord, reverse judgment. Suit was decreed, appellate court reversed the judgment.
So what is your submission today?
Today, my lord, matter may be restored in terms of the order dated 15/7/2024.
Heard Mr. A.K. Purkesto, learned counsel for the learned senior counsel, assisted by Mr. Learned counsel for the applicant. Mr. Purkesto, learned counsel for the applicant, referring to order of this court dated 15/7/2024, submits that the respondent number 1, 2, 4, and 5 were given the last opportunity to contest this interlocutory application. And as the aforesaid respondents failed to turn up and contest the petition, Mr. Purkesto submits that the present petition may be allowed. Having heard the submission of learned counsel for the applicant, I have carefully gone to the order dated 15/7/2024. And it appears that last opportunity is afforded to the respondent number 1, 2, 4, and 5 to contest this interlocutory application, but they have failed to, but all the aforesaid respondents remain unrepresented today. Accordingly, as prayed for by Mr. Purkesto, learned counsel for the applicant, RSA number 63 of 2008 is restored to the file. While recalling the order dated 7/8/2019. In view of disposal of this IA, the registrar lists the RSA number 63 of 2008 before this court. Before the court.
33 and 34.
So do we fix it that or that?
Subject to lordship's convenience.
After 2 weeks?
After my lord, in the first week of September.
First week of
Second
September.
week of September. I mean, second week of September.
After 4 weeks? 4 weeks.
33 and 34.
Obliged.
May I please your lordship? Lordship, service is complete. Respondent number 6 has entered appearance and respondent number 1 to 5 is yet to enter appearance. I'm for the respondent number 6. Let the matter come for admission. It may be taken after.
Heard, Miss?
R. Yadav.
Learned counsel for the petitioner and madam?
D. Pathak.
Learned counsel for the respondent number?
6.
6. It is submitted at the bar that service is completed and the matter may be fixed for admission.
The lordship interim may continue.
Accordingly, it is provided that registry shall list the matter for admission hearing on next date. Till then, interim order passed earlier shall continue.
35 and 36.
Please, your lordship. Lordship, respondent number, service upon respondent number 2 and 3 are pending, lordship.
So I am appealing for respondent number 2.
You are paying for respondent number 2 in contempt, actually, item
Yes,
36.
Today
Item 35. Service upon 2 and 3 are pending. We have to take fresh study, lordship.
2 and 3.
2 and 3. FAO.
And in 36, Mr. Zain, you are appearing for respondent number 2.
in contempt.
Yes, yes.
Respondent number 2 in contempt.
In item number 36, lordship, they have filed a reply, but that is not on record. We need to file they have filed an affidavit in opposition. We need to file a reply in item 36, but that opposition is not on record.
Okay, one by one. Let me dictate the order in 35. Heard, Mr.
G. Khandelia, lordship.
G. Khandelia, learned counsel for the appellant. And whether anybody appeared on behalf of respondent number 1?
Yes, ma'am. I am appealing.
And you, Mr. S. Sunsetti,
Yes.
learned counsel for the respondent number 1. The learned counsel for the appellant submits that service upon respondent number 2 and 3 are yet to be completed. You want to take fresh step,
lordship,
and he may be permitted to take fresh step upon respondent number 2 and 3. Pair is accordingly allowed. Step be taken by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks.
Lordship, it will after 5 weeks because respondent number 2 is
5
from
weeks.
Delhi.
Okay, 5 weeks.
So I will take no price.
You offer?
5.
5. Respondent number 5. Your good name, please.
NR.
Okay, take down. 30, 35. Then in 36, heard Mr.
G. Khandelia.
G. Khandelia, learned counsel for the petitioner, and Mr. R.K. Zain for the respondent number 2, and Mr. S. Sunsetti, learned counsel for the respondent number 1. Mr. Khandelia submits that the respondent number 2, both of you have filed affidavit in opposition.
No, I have filed affidavit.
You have not filed.
I have it.
You have filed. that respondent number 1 and 2 have already filed affidavit, but the affidavit in opposition, but the same are not available on the record. Accordingly, it is provided that recessal placed on record the affidavit submitted by respondent number 1 and 2 on next date. List the matter after 4 weeks, together with the
I need to
5 weeks.
reply.
5 weeks.
5 weeks.
In the meantime, no, unless you receive the copy, how can you file?
They have actually.
They have served it.
Yes.
Acha, acha.
My lord, in contempt, there must be so cause, not affidavit. We have
Because-
filed so cause.
Yeah, I so in the contempt.
Yes.
So yeah, what?
Not affidavit. So cause on affidavit.
Yes. Okay, the thing, no? Suppose on affidavit. The learned counsel for the petitioner submits that he will submit reply to the aforesaid so cause. Here is accordingly allowed. List the matter after 5 weeks. 5 weeks.
Much obliged.
37.
Okay. Mostly, this note shows that the respondent number 2 and 1 and 2 step was taken, but it was answered, Lordship.
Return answer.
Return answer. Who may be allowed to take fresh step, Lordship.
Your good name?
M.H. Ali on behalf of Mr. S. Ali.
MN?
M.H. Ali,
Mr. M.S. Ali, learned counsel appearing on behalf of
appellant. S. R.
A. Sahad, learned counsel for the appellant. Submits that notice issued to the respondent number
1 and 2.
1 and 2 return answer with a report. Then he may be permitted to take fresh step upon those two respondents. Pair is accordingly allowed. Step be taken within a week from today by registered post with AD and also by usual process. List the matter after 4 weeks.
4 weeks, Lordship. Obliged, Lordship.
38.
May I please?
Yes.
May I please? Lordship, an affidavit in opposition has been filed by the respondent number 5. We need some time to file a reply on this. Kindly grant us 3 weeks time.
Third, Mr.
W. Rahman on behalf of Mr. A. Chaudhary, A.D. Chaudhary.
My lord, I am appearing for all the respondents. We have filed an affidavit in opposition. Our suit is being stayed by this honorable court. The case is in brief that they have filed an application under Order 9 Rule 7 for setting aside an order of ex parte proceeding ex parte. Against that order, they have challenged the CRP IO. And our entire suit has been stayed, and the suit is at the stage of cross-examination of the PWs. So, my lord, there is some urgency.
So 1 week time you can take?
My lord,
Kindly.
because they are enjoying the stay order. They are enjoying the stay order. My suit has been stayed. Suit is at the stage of cross-examination of PWs.
Third, Mr. Surimso, learned counsel appearing on behalf of Mr. A.D.
Chaudhary.
Chaudhary. Learned counsel for the petitioner and Mr. Thor, learned counsel for the respondent. The learned counsel for the petitioner submits that the respondents have filed their affidavit in opposition, and the petitioner will file reply to the aforesaid affidavit in opposition and press for granting him 3 weeks time. However, considering the facts and circumstances on the record, 1 week time will be sufficient. You can file a reply. There is allowed for 1 week. List the matter after 1 week.
Obliged, my.
4041.
Lordship, service is complete. As per office note dated 3/6/24.
Third, Miss,
K. Bhattacharya.
learned counsel for the petitioner.
Lordship, there is an interim order in item number 41 that may continue.
Ms. Bhattacharya, Learned Counsel for the petitioner submits that service completed. Accordingly, it is provided that registrar shall list the matter for admission hearing. Interim order passed earlier. Interim order, if any, passed earlier shall continue.
There is an interim order only in item number 41, not in 40.
41, 14 to interim order continue. Yes, interim order.
In 40, there is no interim order.
No, Lordship.
Okay. In 40, interim order shall continue.
There is an interim order in item 41.
Yes. 43 and 44.
May I please your lordship? Lordship, we need more time to file affidavit.
Yes.
Lord, I appear for response number 1A to 1D. So there's an order dated 24/6/2024, and a prayer was made for filing affidavit with medical certificate. And the case was to come immediately after vacation. But it's an old matter, my lord, for condonation of delay. So, how much time do you want? 3 years.
But your good name?
A Khatun.
A Khatun, Learned Counsel for the Learned Counsel appearing for Miss
M Islam.
Mr. M Islam, Learned Counsel for the applicant, and Madam
Miss B. Chaudhary.
Miss B. Chaudhary, Learned Counsel for the respondent number
1A to 1B.
1A to 1B. Ms. Khatun submits that she may be granted
She is seeking 3 weeks time, my lord. That will do, my lord. She is seeking 3 weeks time.
prayed for granting her 3 weeks time to file affidavit. Affidavit in respect of what?
Affidavit কি করেছে কোয়া?
Hmm?
I don't know. They actually, what had happened, my lord, there was a ground for condonation of delay that the person concerned was not keeping well. So a medical certificate they wanted to submit along with the affidavit. And
Acha. That she may be granted 3 weeks time to file an affidavit enclosing the medical certificate. Is there any direction of this court?
yes, because there
As
is a
per direction of this court dated
Yes.
24/6/2024. Here is accordingly allowed. Recessal is the matter after 3 weeks.
46.
I deeply apologize, Lordship, for the interjection, Lordship. In item number 38, Lordship, there was an interim order. Lordship.
Interim order.
That may be considered.
Item number
38, Lordship.
38. 38 interim order shall continue.
45. Item 45.
My lord, we took step, my lord, by registered post, my lord. Kindly see the office note, my lord, 25 of July, my lord, last, my lord, long order, last 2 paragraphs, small paragraph. My lord, presumption has been drawn by the lower court, my lord. And so, my lord, nobody, my lord, appearing. My lord, due service, my lord, coach, and postal receipt. Last 2 paragraphs. In view of the fact, it may be presumed that the service in respect of the 1 to 6 has been completed.
Mr. S. Sohan. And I heard Mr. S. Sohan, Learned Counsel for the applicant. Mr. Sohan referring to order dated 25/7/2023 of the Lawazima Court submits that service upon respondent number 1 to 6 have already been completed. But no one appears on behalf of those respondents. No, but the aforesaid respondents remain unrepresented today. So recusal is the matter for
Consideration of delay, consideration of I. 3573.
recusal is the matter for admission on
Admission melody, condonation first mind. Condonation is
Oh,
here.
condonation, yes.
47 days delay. Melody was being shown melody in paragraph 4, 5, 6. The old man melody was suffering from lip
So for hearing on the IA number 3 for hearing on this IA on should we fix a date?
Yes, well, early date.
When?
28 August. Item 46.
Please, your lordship, kindly adjourn the matter for today, lordship. My senior is. Lordship, IS filed for modification of the order dated 12/2/2014 to 24, lordship. This IS filed for modification this order. Learned Trial Court has granted respondent wife 50% of his pensionary benefit. The petitioner is a WNGCL of employee. There is no provision for pension. Therefore, he was retired on 31st May 2024. Thereafter, we have filed a petition trial court, and trial court granted the 50% pensionary benefit on behalf of the wife. Thereafter, the petitioner approached this honorable court stayed the order and on 12/2/2024 and directed him to pay the monthly maintenance 30,000. But he is not paid last 2 months, lordship.
Yes.
My senior is in bed rest due to heart surgery, lordship. So kindly adjourn the matter for today.
Heard Miss A. Begum,
Yes, lordship.
Learned Counsel for the applicant, and also heard Miss
And Rahman.
Learned Counsel for the respondent. The Learned Counsel for the respondent submits that arguing counsel, Mr. Who is the senior?
Ayat Talukdar.
R.A. Talukdar. I.A. Talukdar. I.A. Talukdar is indisposed of, and therefore it is contented to list the matter after when?
Next week, lordship.
After 1 week? Okay, after 1 week. There is accordingly allowed. Recusal is the matter after 1 week.
47.
The action may be given for paying maintenance amount. Whereas I stay in WNGCL quarter, he now presides me to vacate the quarter. There is no alternative accommodation for me, lordship. He is not paying the maintenance.
Let her senior appear. After hearing both sides, we will pass necessary order.
47.
If I may, my lord, the IA is fixed for a substitution of deceased appellant 1, 2, and 4. My lord, the appellant number 1 had died on 27/2023. Subsequently, 2 and 4 had also died. My lord, notice has to be issued.
Heard, Mr.
G. Imtiaz.
Learned Counsel for the applicant. This application under Order 22 Rule 4 of the Code of Civil Procedure is preferred by the legal heirs of the deceased appellant number 1, Tilok Hira, and appellant number 2, Puspa Hira, and appellant number 4, Dabhagi Hira, in RSA number 248 of 2010. Where is the petition and the documents? You have not enclosed any documents.
No, my lord, there's a delay, my lord. We have filed an IA for condonation of delay, and subsequently, my lord, the matter has also been abated.
Let notice be issued to the respondents, returnable in 4 weeks. Shall be taken by registered post with AD and also by usual process within a week from today. List after 4 weeks.
Yes, deeply obliged.
Item 48.
My lord, there is some mistake, my lord. This case is disposed of. There is some mistake from the registry. They may have failed to see that it has been disposed of. I have the judgment with me. My lord passed the judgment on 17/7/2024. My lord, if my lord does not have a copy, my lord can have a look. And my lord will not have jurisdiction to pass any orders in this case. Because the case is has been finished, my lord. The case is complete now. Has been disposed of by my lord judgment. So how will my lord consider it again? I have given the judgment, my lord.
Oh, racial discord. Okay, heard me, sir.
Mr. K.K. Bhattacharya, I am appearing for the respondents 1 and 3 for the state of
respondent
Assam.
number 1 and 3
For the state of Assam.
for the state of Assam.
And 1 and 3 are the state parties, state of Assam parties.
Mr. Bhattacharya submits that this IA become infractious as the writ petition criminal 37 of 2023 has already been disposed of by order dated 17/7/2024. By judgment and order dated 17/7/2024. In support of his submission, Mr. Bhattacharya has produced the copy of judgment and order of this court dated 17/7/2024 in WPC criminal number 37 of 2023. In view of the disposal of WP within bracket CRL 37 of 2023, this IA become infractious and accordingly the same stands closed. The judgment furnished by Mr. Bhattacharya shall be part of the record.
Obliged, man.
Sorry, number 51 for stay matters.
Your Lordship, I'm appearing for respondent number 1 and 2.
Respondent number 1.
1 and 2.
1 and 2.
Today is for report.
Report from?
For to submit by the superintendent of police, verify the name and address of the victim's wife. Order dated, Your Lordship, last order dated 24/6/2024.
May I please, Your Lordship? May I please, Your Lordship? My lord, here for the insurance company, my lord, my lord, we have filed a transfer petition. The crux of the matter is that two MSC case was filed, one at Gwalpara and one at Guwahati. And the Gwalpara was filed earlier on 28/10/2020, and the case filed at Guwahati was on 4/11/2020. It pertains to the same deceased person. And the case was filed by one wife and mother-in-law at Gwalpara, and here in Guwahati by the wife. Now, after this transfer petition has been filed, my lord, we have been asked to serve to the respondent through Dusty, and we have made the service, and an affidavit to that effect has been filed before this honorable court. And now, while we have been serving the notices, it came to our notice that respondent number 3
and 2 is one and the same person.
Hmm.
Because it was been received by the respondent number 2 has received by herself, and respondent number 3 copy was received by the brother-in-law of the of respondent number 2.
Hmm.
My lord, now he stated that these two persons are the same, being Runumoni.
No, a report
Runumoni
was called
Rabha
for.
and Bornali Rabha, my
No,
lord.
no, in respect of that, a report was called for from the Superintendent of Police Golpara.
Yes, my lord.
The report has not been received.
Yes, my lord. But the issue is that the case filed at Gwalpara, as per the notification of the Guwahati High Court, my lord, in regard to the judgment passed by in Gohar Mohammed, the case where first a MSC case has been filed, other cases has to be transferred to that court, my lord. And to that effect, a notification has been passed by this honor by this
No,
honorable court.
before that, we have to ascertain whether they are the same person or not.
My lord.
So that is the order passed on 24/6/2024.
Yes, my lord.
So let us go by the order. Heard, Mr.
My lord, C. Fukan.
C. Fukon, learned counsel for the petitioner, and Madam,
P. Datta.
learned counsel for the respondent number 1 and 2. 1 and 2. Order dated 24/6/2024 indicates that the Superintendent of Police Golpara was directed to make an inquiry as to whether Srimati Runumoni Rabha and Srimati Bornali Rabha are one and the same person. But the said report has not yet been furnished by the Superintendent of Police Golpara. So have you provided a copy of the order to the Superintendent of Police?
My lord, it was directed to the registry, and
Who is TR?
para number 6.
Who is Mr. TR Gogoi? No. And to that effect, Mr. TR Gogoi, learned government advocate, was directed to inform the Superintendent of Police. But Mr. TR Gogoi is found absent in the court on repeated call. Recessal leaves the matter after 1 week.
My lord, interim order. We continue.
Interim order passed earlier shall continue till next date. A copy of this order. Narration shall furnish a copy of the order to Mr. TR Gogoi, learned government advocate, so as to enable him to produce the report of the Superintendent of Police before this court on next date.
Item for hearing, item number 50. My lord, this is a matter of 2012. But my senior, Mr. K. N. Chaudhary, has left the court premises because of the climatic change. Because of heavy shower is coming, he has just left the court. So I have taken consent with both the parties. Time is also not very much short. It's already 4 p.m. It will take some time.
On the pair being made by Mr. A. Dhar, learned counsel for the appellant, having not been objected by Mr.
C. Goswami,
learned counsel for the
Respondent.
respondent. A recessal list the matter on when we will fix it that suggested it.
September last month.
No.
29th August.
29th August. 29th August.
It's okay.
Yes.
Obliged.
On that matter, recessal list this matter as yeah, I think it is going
Top of the list.
top of the list. top of the list.
Item 55.
May I please, your lordship. Lordship, the day before yesterday, lordship, other side submitted no objection to the prayer made with the petition, lordship. Here in this case, lordship, order dated 5/7/2023 in FC Civil 902 of 2022 was challenged, lordship. And in that order, lordship, on that day, lordship, we filed a petition for seeking some time for filing written statements. And my prayer was rejected, and that order has been challenged before lordship. To which lordship other side does not have objection, lordship. If the prayer is if the prayer is accepted by a lordship, other side does not have objection, lordship.
Okay, heard Mr. A.K.
A.K. Ahmed.
Ahmed, learned counsel for the petitioner, and Mr.
M. Rahman.
M. Rahman, learned counsel for the respondent.
And only my prayer is that, my lord, on the date, my lord, they may file the written statement. No further adjournment may be given
Definitely, lordship.
in that court, my lord.
We may be directed
Because
to appear.
we have
Okay,
raised no
okay,
objection
all right.
as because for the delay only.
In this petition, under Article 227, within bracket 1 of the Constitution of India,
Lordship.
read with Section 115 of the Code of Civil Procedure. The petitioner, Abhijit Nath, has challenged the correctness or otherwise of the order dated 5/7/2023.
Sorry, lordship. Lordship, petitioner is Nabanita Chaudhary, lordship.
In the main FC civil case.
Acha, Nabanita Chaudhary. No, who filed this application?
Lordship, Nabanita Chaudhary, petitioner wife.
Nabanita Chaudhary.
This revision petition was filed by Nabanita Chaudhary, lordship.
Okay. Challenging the correctness or otherwise of the order dated 5/7/2023 passed by the learned principal judge Family Court number 2, Family Court 2, Kamrup, in FC within bracket C, case number 902 of 2022. It is to be noted here that by the impugn order dated so and so, the learned principal judge Family Court was placed to reject the petition under section petition number 509 of 2023, dated 5/7/2023. Wherein a prayer was made to grant some time to file a written statement as 90 days. As the stipulated period of 90 days already elapsed. Mr. Ahmed, learned counsel for the petitioner, submits that in the aforementioned case, the petitioner has received notice, but he could not file a written statement within the stipulated period because of
Because of illness, lordship.
because of her illness.
Lordship.
Have you filed any medical document here?
No, lordship.
Then how can you substantiate the same?
Lordship, my prayer was rejected by the learned court below, lordship, on the ground of 90 days elapsed, lordship, not on the ground of illness.
That's all right. You could not file the WS within the stipulated period.
Lordship.
Why?
Lordship, actually calculation is erroneous, lordship. 26/5/2023 was the first date for written statement, lordship. 26/5/2023 after completion of
Counted from whose date? From the date of receipt of notice?
lordship, actually the first date was 25.
And on receipt of the aforesaid written statement? the learned principal judge family court shall accept the same, now take the same on board, and thereafter proceed to hear the matter in accordance with law in terms of above this CRPIO number 221 of 2023 stands disposal.
No adjournment may be given on that date, madam. That may be added.
Only one opportunity,
Lordship,
only one opportunity.
much your lordship.
Obligement.